Sarve bhavantu sukhinah. Sarve santu niramaya. Sarve bhadrani pashyantu. Ma kaschit dukhabhag bhavet. May all be happy. May all be free from ailment. May all see the auspiciousness of the world, and may no one suffers. This profound verse encapsulates the essence of knowledge sharing and growth, which aligns perfectly with the purpose of our gathering today. A very warm good morning to everyone present here. My co-host,
I, Gautami Chakravarti,
and I, Anisha Sharma, are indeed honored to welcome you all to this two-day workshop on technology transfer and intellectual property, jointly organized by Technology Transfer and IP Services of Sree, Chitra Tirunal Institute for Medical Sciences and Technology, TIPS at TMED, Thiruvananthapuram, and DPIIT Chair of National Law University, Assam. This event brings together some of the brightest minds in the field, distinguished legal professionals, esteemed professors, aspiring students, creating a platform for meaningful dialogue and knowledge exchange. Before we commence, I would like to take a moment to acknowledge the distinguished dignitaries who grace us this occasion with their presence. Professor Dr. V.K. Ahuja sir, Director of Indian Law Institute, New Delhi. Professor Dr. K.V.A. Sharma sir, Vice Chancellor, National Law University, Assam. Professor Dr. Nripendralal Mitra sir, former Vice Chancellor, NLSIU, Bangalore. And Mr. Balram Shankaran sir, the CEO of Technology Transfer and IP Services of Sree Chitra Tirunal Institute for Medical Sciences and Technology, Trivandrum, Kerala. And all of our distinguished guests among us today. We are truly privileged to have such luminaries among us. I also would like to extend my heartfelt gratitude to TIPS TMED and DPIIT Chair of National Law University, Assam, for their collaborative efforts in organizing this two-day workshop on technology transfer and intellectual property.
Good morning everyone. To begin with the inaugural session of the two-day workshop, let me please welcome on stage Dr. Pankaj Kumar, DPIIT-IPR Chair, Professor from National Law University and Judicial Academy, Assam, to give the welcome address. So, please.
Now, as we start with the program, I would like to invite our dignitaries on the dais. First, please welcome on stage with a huge round of applause, Professor Dr. V.K. Ahuja sir, Director of Indian Law Institute, New Delhi. Sir, please. We have a big round of applause, everyone. Next, I would like to invite on stage Mr. Balram Shankaran sir, CEO of Technology Transfer and IP Services of TIPS TMED. With that, over to you, sir.
Thank you. See, as usual, nowadays there are so many IPR programs, and most of the times it is noted that due to if we don't charge any fee, if it's free, there are so many participants registered in these programs. Over 50 participants registered from outside. And that's why we hardly much bothers to our own students for these programs. And let's see the situation. So many times such happens. Anyway, namaskar to everyone. So Honorable Vice Chancellor of Naluja, Professor Dr. K.V.S. Sharma sir, our esteemed chief guest, Senior Professor and Mishra sir, Dr. V.K. Ahuja sir, Director, Indian Law Institute, New Delhi, Balram sir from Technology Transfer Office, Kerala, respected faculty members, researchers, innovators, industry experts, and dear participants. So a very warm welcome and heartfelt welcome to you all. It is truly an honor to inaugurate this two-day workshop on IP and Technology Transfer, jointly organized by Technology Transfer and IP Service Unit, TIPS, under Sree Chitra Tirunal Institute of Medical Science and Technology, Thiruvananthapuram, and we all at DPIIT-IPR chair at Naluja. This workshop brings together an exceptional. This is not an exceptional gathering, although we did it online on YouTube. So this is to discuss and explore the critical role of intellectual property rights in fostering innovation, commercialization, and technology transfer. IP is the backbone of economic growth, research advancement, and industrial collaboration. It is not just about protecting ideas, it is about innovation, enabling knowledge sharing, and translating research into impactful societal applications. Through this workshop, we aim to provide a comprehensive understanding of patenting, licensing, commercialization, and the legal framework of technology transfer, key elements essential for a thriving innovation ecosystem. One of the special highlights of this workshop is IP Clinic and Technology Showcase that will be scheduled on next day, which is already intimated under IPR FC. We have IPR facilitation cell here in Naluja, as initiated by our ex-Vice Chancellor Professor Ahuja sir, which offering a unique platform for inventors, startups, researchers to discuss their IP needs, like filing of patent, design, trademark applications. So I am confident that the insights shared by our eminent speakers and resource persons will inspire new collaborations and strengthen IP awareness among all the participants. I extend my sincere gratitude to our Honorable Vice Chancellor, Professor Dr. K.V.S. Sharma sir, Registrar sir and Academic Registrar for their consent and constant support in such IPR events and activities, along with advancing IP education and research at Naluja. A special thanks to our distinguished speakers and guests for taking time to share their expertise with us today. With this, I once again extend a warm welcome to all, and I look forward to an engaging and thought-provoking 2 days of the discussion. Thank you.
Thank you so much, Pankaj sir, for your kind address. Now we shall be proceeding with the felicitation program of our esteemed dignitaries and resource persons.
To felicitate our esteemed dignitaries, first, I would like to invite on stage Dr. Pankaj Kumar sir, DPIIT-IPR Chair, Professor, National Law University, to felicitate Professor Dr. V.K. Ahuja sir, Director of Indian Law Institute, New Delhi. Can we please have a round of applause? Now, I would like to invite on stage Professor Dr. Nripendra Mitra sir, former Vice Chancellor, National Law University, Bangalore. To felicitate sir, may I please welcome on stage Professor Dr. KVA Sharma sir, Vice Chancellor, National Law University, Assam. Next, we would like to felicitate Professor Dr. KVA Sharma sir. Now, we would like to felicitate Balram Shankaran sir, CEO of Technology Transfer and IP Services of Sree Tirunal Institute for Medical Sciences and Technology. To felicitate sir, may I please invite on stage Professor Dr. Sree, Research Officer, DPIIT-IPR Chair, National University, Assam. Can we have a round of applause, everyone? Next, we would like to felicitate Ms. Nimita CG Ma'am, Scientist at Technology Business Division, TIPS TMed, Trivandrum. To felicitate Ma'am, may I please welcome on stage Dolly Kumar Ma'am. Extremely sorry for that. Now, I would like to invite on stage Ms. Sandhya CG, Scientist at Technology Business Division, TIPS TMed, Trivandrum. To felicitate ma'am, may I please welcome on stage Dolly ma'am to felicitate Sandhya ma'am. Now, I would like to invite on stage Dr. Nimisha K. Ma'am, IPR Associate, TIPS TMed, Trivandrum. To felicitate ma'am, may I please welcome on stage Dr. Sharmishta Barua Ma'am, Research Officer, DPIIT-IPR Chair. Now, I would like to invite on stage Dr. Hirat Ranjan Das, Innovation Manager, ICT-CE, Innovation Cell, Ministry of Education. To felicitate sir, may I please request Pankaj sir to felicitate. Now, as we proceed towards the inaugural session, we would like to first invite on stage Professor Dr. Nripendralal Mitra sir, former Vice Chancellor, National Law University, NLSIU Bangalore, to address our dear participants. Sir, please.
Good morning to all of you. I will first request my time. What is my time? 1 minute, 2 minutes, 5 minutes?
Sir, up to 5 to 10 minutes, sir. 5 to 10 minutes. 5 to 10 minutes.
5 minutes?
Yes, 5 to 10 minutes, sir.
5 to 10 minutes. Because once you ask a person like me, Mr. Professor, his switch is in the leg. So you have to operate the switch, asking me to go and sit down. It will automatically. I may be the odd person in this workshop because I am in the twilight. When TRIPS started, not TIPS, TRIPS. It was not in the agenda of Marrakesh. It was not in the agenda of Marrakesh in 1995. TRIPS were actually in the backbench of US delegates. US delegates brought back TRIPS on the table and insisted that next morning it has to be passed. Otherwise they withdraw from WTO. Of course they have withdrawn from WTO afterwards. But they gave the threatening on the initial stage itself. And at the stage, the whole night there was a confabulation. And the confabulation, all the Middle Eastern countries, they had to sign on the dotted line by night. 3 o'clock night, it was already exceeding 124 nations signed on the dotted line without any discussion. India, of course, was the last to sign, but without any discussion and without any word also. So Marrakesh, in that there is only one voice. There was only one voice, the voice of Scotland. The Scotland delegates, they wanted that they will sign only if whiskey gets the patent. Now, Americans said, how can it happen? It is a prior art. We cannot give, But they said, without that, we will be withdrawing. And then, if Scotch whiskey goes out, French wine will go out, and whole Europe will go out. So that becomes a pressure on the US, and then US designed, in confabulation, there has to be another right. Can we call it geographical indication? GI. So in the morning they said, you people, Scotch people, French people, you are going to get a new right. We have designed higher than the patent right. Patent right is the queen of the intellectual property. Higher than that. And that's called GI, geographical indication. So GI came out and Scotland was very happy to get GI. In my fag end of my life, I saw this really happen in front of me in 1995, and I am now seeing today, when I am in twilight, after 30 years, that it is being debated here between two contesting things. One is coke. In a confidential communication, if you do not take patent, then there is a confidential information. And confidential information goes without any time limit. Patent has a time limit. At that time, India's time limit was 7 years. So I had to sell this patent right to Indian Institute of Science. And Brahmachari, who was also later on became the secretary, Brahmachari asked me, sir, you said patent right? 7 years, how much time you require for getting a patent, you know? It requires 9 to 10 years, but I get only for 7 years. So it was quite tough to come in line with TRIPS agreement that at least 20 years. So patent law in India had to change. There are a lot of things that you have to change. Was both in the committee of copyright and in the committee of patent. But having no any inkling, he doesn't have intellectual property at all. In that sense, Coke is a confidential communication. First time Coke learned when PepsiCo came, Pepsi Cola. An employee of the Coke came out and close by started Pepsi. Now Coke cannot go to the court, though their confidential system, secret, trade secret, has a very strong law. At that time, Millennium State Secret Act was not there. Therefore, Coke did not contest. PepsiCo came. Now this word is designed called technology transfer. Technology transfer. Okay? So if you keep your secret, your research secret, then in that case it is actually becoming a technology. Technology is a procedure. Technology is a procedure and patent is a product. Now India used to follow patent procedure. In the procedure also India used to. India did not have at that time product patent, it was only process patent. So we understand that we have to walk through. The last 30 years you must have walked long distance. As I walked through my heydays to twilight, similarly you people also must have walked 30 years quite far. Now I only remember when I was senior partner of a law firm, and I was invited by IIT Chennai, dealing with leather technology and having a kind of model leather technology transfer agreement, which afterwards it was very common. That model was very common. It was quite long back, it should be in 2000. So technology transfer doesn't have any time limit. If you can keep your technology, that means if no reverse engineering is possible, all product patent reverse engineering is possible. Only process engineering always may not be possible. Product is always possible. So, where is technology transfer? Now then I had a kind of, my time is still there, 2 minutes. I take 2 minutes. I had to give an advice to BPL. BPL, we had a technology transfer agreement with BPL China, with Japan, of picture tube, colored picture tube. Now picture tube has a tail end. Now for 5 years, there was a technology transfer agreement. For 5 years, there's internalization of the communications of technology from viewer to the 5 years. In 5 years, there is one home. Indian engineers, BPL engineers, they used to go to Tokyo and enjoy with their families. And those engineers used to come over here. 5 years. After 5 years, now that as soon as they started producing, and BEL, they started producing their own, the tail end was broken. Repeatedly they tried, they could not hold it. Then there was a question of should he go to the court. They asked Japanese, please, this is what is happening. You have given us technology, you are using the technology, but tail end is. They said 5 years. After 5 years, we are not accountable for anything. For 5 years, you didn't have any problem. Now, when it is in your hand, it is a problem, so it is your problem. We have nothing to do with that. Right? So, there was a long now legal communication, legal battle. In that, perhaps I had a role. That was designed. Not that I am knowledgeable in intellectual. I don't have intellectual property. So, happy about GI. So, yesterday when Ahuja came, I told him, Ahuja, please give me your email address. I will send you an article. The article is on GI. And I criticize that in the context of the history. GI actually, if you are using, India is misusing GI on traditional knowledge. If on all traditional knowledge we go on this way, GI like Rasagullah, okay, then this Reno can be also a GI product, which is a traditional knowledge. Traditional knowledge, indigenous knowledge, if you use GI on them, it will be really a sad day for India. But we are doing that now. And we are actually not thinking that India could have designed its own whiskey, its own wine, but because of our British understanding of excise, and we are still continuing that excise duty. We have not changed. Mahua is one very important thing where India could have designed its own product and then product liability as well. Now this is, I am sure, going to be now taken away from India. Okay, the process has already started. More flowers are now collected. They are correlated, they are accumulated, and it is being exported from India to abroad. So if you really try, I think only the legal scholars, okay, if they come up, perhaps this thing can be reversed. Thank you. I have taken a few minutes more time. Thank you very much.
Thank you so much, Professor Dr. N.L. Mitra, sir, former Vice Chancellor from National University, Bangalore, for his insightful perspective on intellectual property, confidentiality, trade secrets, GI and TK, and inspired us to think more critically about the evolving dynamics of technology transfer and intellectual property. On behalf of TIPS and team, National University Assam, and all the participants, I extend our heartfelt appreciation and gratitude. We sincerely hope to continue learning from you, sir. Thank you so much.
As we proceed with the inaugural session, it is my honor to provide a brief introduction of our chief guest and resource person, Professor Dr. V.K. Ahuja, sir. Professor Dr. Ahuja is the Director of Indian Law Institute. He holds a PhD in LLM degrees from University of Delhi and MPhil degree from Jawaharlal Nehru University, New Delhi. Before joining as director of the Indian Law Institute, Professor Ahuja sir has also worked as the Vice Chancellor of National Law University and Judicial Academy, Assam, from 2021 to 24. Professor Ahuja is the Senior Professor at the Faculty of Law, University Delhi. He has also served as Joint Director of Delhi School of Public Policy and Governance, established under the Institute of Eminence, University of Delhi. He has also served as the Professor in charge of Law Center, Faculty of Law, University of Delhi from 2017 to 2020. He has served as 30 years of teaching and is a research experience at undergraduate and master's level. He has written 5 books on intellectual property rights, international law, and mediation. He has also written 2 volumes of Halsbury Annotated Statutes of India.
That's it. Thank you.
With that, it is my honor to welcome you, sir, Professor Dr. V.K. Ahuja, sir. Please welcome him with a round of applause.
No, sir, then you sit, sir. I don't have it. Then you can sit. I will go and listen. I will listen. Listen. I will listen. I shall be.
Guru of Gurus, Professor N.L. Mitra, Professor K.V.S. Sarma, the Honorable Vice Chancellor, N.L. Assam, Sree Balramji, Professor Pankaj, Professor Kailash Dinger, Dr. Dhoni, Dr. Ramista, admin officials of Laluja, and the dear participants from Tirunal Institute for Medical Science and Technology, Tirunal. Very good morning. I'm becoming nostalgic right now. For 3 years I was the host here. Today I'm standing as a guest here. So this is the new role, new position, and it is a good one, the present one. I was listening to Professor N.L. Mitra very carefully, and the way he had narrated the historical background of the TRIPS agreement in a nutshell within just 5 to 7 minutes. Well, that was commendable. I recall my time when I was a student of JNU and Delhi University. I did my LLM, MPhil, PhD from these 2 institutions. And right from 1989 onwards, I was taught one thing by my professors at both institutions, at Delhi University and JNU, that IPRs are something which are, not helping us because our approach is fully public interest centric. What I was taught by my teachers was that India is not willing to become a party to Paris Convention of 1883 because it provides for stronger protection to the IPR holders. When we became a party to TRIPS agreement, obviously we had to be, we had to abide by the Paris Convention also. We were already a party. Now, some 30 years back, or 35 years back, I cannot teach the same thing to my students today. And friends, India from IP consumers has become an IP producer today. The entire things got changed. Our laws got overhauled, and when I say that if you have to study IPR, study them in 2 phases: the pre-TRIPS era and the post-TRIPS era. Then only you will understand how we were doing prior to the adoption of TRIPS agreement and how we are doing it after the adoption of TRIPS agreement. As sir had very rightly pointed out, the term in India for patents protection was 5 to 7 years only. And it was very right, when he said that so far as the grant of patent was concerned, it would take more than 5 years, maybe even 7 years also. So by the time the term, patent was granted, the term will already get over. And that was the reason, why some new products were not being introduced into the Indian market, new medicines were not being introduced into the Indian market. And patent was the only problematic area in the entire TRIPS agreement because of which, we were opposing the inclusion of intellectual property in the mandate of GATT, as sir had rightly pointed out, because it was nowhere on the agenda. It was brought in when the round progressed. Today, we have, TRIPS compliant laws. Not only that, in 2016, the government came out with national IPR policy. Now, there are 7 objectives in that, and of course, it is showing the shift from IP consumer to IP producer, how we have to talk about, a creative India, innovative India. Now, the tagline which had been used in that, of course, we have to produce the IPR and we have to take it to the market also. Well, friends, technology transfer supports the life cycle of technology from inception to market diffusion and commercialization. Now, through transfer of technology, the owner of technology transfer it in 2 ways. One, that transfer can be done through assignment, what we normally call as selling something to somebody without having any rights over it. And the other one is to give the permission, what we call as licensing, where you continue to be the owner of the technology, but you allow multiple people to work on it. The technology includes, as sir was rightly pointing out, the intellectual property, the scientific findings, the data knowledge, the know-how, and many other things. Now, through this technology transfer, IP flows from its creator to the end users, that is the consumers. Now, this IP creator may include an individual, a person, legal person, a university, a research institution, a governmental department, etc. Now, this IP so created by them have to be taken to the end user in the shape of a new product or service. The ultimate goal of the technology transfer is to benefit the society as a whole. Friends, technology transfer is a win-win situation for all the stakeholders. So far as creator of that technology is concerned, that creator recoups the investment along with reasonable profits by transferring its technology. The receiver of the technology transforms that technology into new product or service, and by doing so, that receiver earns a lot of benefits. The users get the new product or the service in which that new technology had been used, and finally, the society at large is benefited by the technological development of the country. Friends, the technology transfer gives a boost to the collaborative programs. I'll just talk about the 2 initiatives of the Government of India, Make in India and Atmanirbhar Bharat. Now, these are the 2 initiatives where, of course, through transfer of technology, we can really make a lot of change. If you look at the Patent Act of India, which was which means that if a patent has been given, that patent holder will have to set up an industry in the country and will start the manufacturing. But Paris Convention as well as the TRIPS agreement says that local manufacturing is not mandatory. So even if a patentee is importing products from outside, that will be taken equivalent to local working of the patent, and this is how they can continue. But now try to understand the difference between the two, the local working and the importation. Now assume that there is a patent which has been granted in India, and the patentee set up a plant in China, manufactures the product there, right? And it is importing that product here in India. So look at the consequences. There would be a technological and economic development of China. There will be employment opportunities in China. There will be more and more revenue which will be generated there. So obviously there would be more and more taxes also on that profits which those companies will be making, and that will be going to the government of the China. Now with organized sector, there is an unorganized sector which also develops. Say for example, if an industry has been set up, now the people like if you people know about Delhi and Gurgaon, the Maruti plants were set up in Manesar, that was near Gurgaon, I mean even beyond Gurgaon. Now when you set up those plants at those places, because obviously every country has that land issues. Now apart from the people who are working in that plant, there would be other kind of an unorganized sector would come up. Say for example, there would be the people who will be using the local transportation, so rickshaw puller, the auto wala, and other people would be there. There would be guest house facilities over there. There would be paying guest facility would be there, right? That will help the people of that particular locality to develop. There would be pan wala, there would be fruit chaat wala, there would be bhutta wala, there would be chai wala, there would be so many other people who will be working there, having some sort of their setup. So when you start local manufacturing at a place, it's not only that we are contributing to the economy through that organized sector. There is a parallel unorganized sector also which is coming up and which is also helping the country. And therefore it becomes very important to have the local manufacturing. So friends, for successful technology transfer, it is important that all the stakeholders operate in an effective innovation ecosystem. An interconnected network of government, industry, university, and research institutions and enabling factors such as human capital, technology transfer structures, and sophistications of business and marketing. In such an ecosystem, the parties bring their resources and expertise together to collaboratively work and achieve technological and economic development. Friends, there is one more thing, Professor Chitra will agree to that in the TRIPS agreement there are at least 3 articles, 7, 8 and 66, where it is talking about the transfer of technology also, right? But unfortunately, that is something which is not happening, and that we had already seen during the pandemic period when India and South Africa brought a resolution for TRIPS waiver, right? And it was materialized, partially materialized, not fully, after more than a year or so, by the time this pandemic had already gone, right? So the principles and the objectives of the TRIPS agreement, as well as the obligations of the developed countries to give incentives to their enterprises so that they can transfer the technology to the least developed countries, that is not happening. So somewhere they are also failing in fulfilling their obligations. I'll speak more about it tomorrow when we'll have a presentation on TRIPS agreement and health. So with these words, I'll stop it here and thank you very much for giving me patience hearing. Thank you very much.
and intellectual property. On behalf of TIPS at TMED and National Law University and our dear participants, I extend our heartfelt appreciation and gratitude. Thank you, sir.
Now, let us proceed towards the keynote address by Mr. Balram Shankaran, CEO of DPIIT-IPR. Mr. Balram Shankaran, sir, is a scientist, senior grade professor at Biomedical Technology Wing of Sree Chitra Tirunal Institute for Medical Sciences and Technology, which is an institute of national importance under Department of Science and Technology, Government of India. He has over 30 years of experience in research and development and commercialization of medical devices. Sir is also the founder and CEO of DPIIT, a non-profit technology business incubator for supporting innovators and startups, development of medical devices and biomedicals. As the CEO of DPIIT, Sir has secured competitive grants for supporting innovators and startups from the Department of Science and Technology and BIDEC. He has also set up a regional technology transfer office at DPIIT with funding from National Biopharma Mission to support the IPR and commercialization of research. Sir has been a visiting fellow at Office of Technology Transfer, National Institute of Health, USA, and a Japanese government scholar. With that, please welcome Balram sir with a huge round of applause. Sir, over to you.
Thank you very much for that introduction. Mom, good morning and greetings from myself and my team who have traveled around 3,500 kilometers to join you and be part of this workshop. And probably it's very rare that scientists and lawyers speak. Even if they speak, it may be for a wrong reason. Anyway, today we are in an age of collaboration, and our institute, our unwritten rule is to take a road less traveled. So we do things differently, even though we are within the government system. We are an institute of national importance created by an act of Indian Parliament. And when I was in the company of some legal luminaries here, I just recalled that there is a connection between the institute and the legal profession, because our institute was founded by a visionary cardiac surgeon, and apart from performing high-risk surgeries, he put a lot of importance on science, and then he thought I should build a science-based institution. And in his way going forward to create this institution, he took the support of legal luminaries, none other than Nani Palkiwala in the 80s. And Nani Palkiwala, as probably some of you know, a very eminent legal luminary, he played a critical role in the establishment of this institute. And the story goes that when the Professor Valyathan, he had conceptualized setting up this facility and he was looking for funds, he had an appointment with the then Prime Minister Morarji Desai. Morarji Desai was so much impressed that I'm not going to give you a small grant, I want the central government to establish this institute, take ownership of this institute. Unfortunately, Morarji Desai's government fell after this bill was placed in the parliament, and then subsequently Indira Gandhi came to power, and this was the only bill which was placed by the previous government that was approved by Indira Gandhi, because she also saw merit in the proposal. So the point I'm making is science and law, they really work hand in hand. And over the years, the institute has been in the journey of innovating, doing research and finding solutions to solve problems of the heart and brain. So they came up with a lot of new innovative solutions. And then before the country was aware of patents. And then going forward, even when the IITs were in their own cocoons of research, our institute went ahead and started working with industry and trying to commercialize these patents. Because a patent is valuable only if it is commercialized. Otherwise, it's just a piece of paper. So that was the foresight with which our institute founders established this. And we had a lot of policies like patenting first before publishing and all those actually reap benefits. And in the year 2020, our institute got the national award for highest rate of commercialization of patents. And we have commercialized such many products which is in the market and which is helping our population in having affordable medical products. And over the period, over some time, we have developed some experience in not the theoretical aspects of patent, not the legal aspect of patent, but on the working of practically how patents have to be used by researchers and how it can be commercialized. And on that knowledge, we set up a technology transfer office with the support of the Department of Biotechnology, and we have a mandate to popularize this. We have a mandate to create awareness all across the country, and it is in part of that mandate that we are here today. So to create awareness, and I wish there were more people in the audience so that this message could have actually gone far and wide. So what we are going to do in the next 2 days is to discuss more on how it's not just about patenting, how it should prudently patent. It's very important. All the patenting is a strategy. How to make patents an asset for you, not a liability for you. So that is the key learnings that we would like to impart to you based on our practical learnings. And I have a very experienced team with me, my colleague Sandhya, and we have patent agents, registered patent agents, Dr. Parveen and Dr. Nimisha here. So we are here, we'll be here for the next 2 days. It's for you to make use of our presence, and if you have anything you want to know or share and exchange. And all this is possible thanks to the efforts of Professor Pankaj. He was really enthusiastic and he went all out to make this happen, and thank you. And I hope he has also invited other experts from the region, and thank you for that. I hope that this will be a productive workshop. Thank you.
Thank you so much, Balram sir, for the very nice speech. So I would like to extend our sincere gratitude for delivering such an enlightening address. Now, as we conclude to the inaugural session of the 2-day workshop of Technology Transfer and IP, jointly organized by DPIIT-IPR and DPIIT-IPR Chair of NLU Assam, I would like to invite Dr. Hirak Das to deliver the vote of thanks.
So is the Innovation Manager at AICT Innovation Cell of Ministry of Education. Sir, please.
Sorry for some misconception. I am doing vote of thanks. So, good morning again. We are coming to the end of this inaugural session of this 2-day workshop on IP and technology transfer. It is my privilege to extend a heartfelt vote of thanks on behalf of DPIIT-IPR Chair Nanuja. First and foremost, I express my sincere gratitude to our esteemed chief guest, Senior Professor Dr. V.K. Ahuja sir and Mitra sir, for delivering their inaugural speech and setting the stage for meaningful discussion on the role of IP and technology transfer. We are honored to have Balram sir, CEO of TIPS, teammate Thiruvananthapuram. I extend my appreciation to all the distinguished speakers, including N. Mitra sir, Dr. Hirak Ranjan Das, who took the time to share their expertise and experience making this workshop. Hopefully, we are going to do great during such technical sessions these 2 days. Valuable learning experience for all the participants, both online and offline. So there is a YouTube streaming also. A special mention to our organizing team, faculty members, research scholars, students, whose efforts have ensured a seamless execution of this event. I would like to thank STEP's team for collaborating with us and supporting this initiative to create awareness and strengthen India's innovation and IP ecosystem. So big thank you all participant research startups, industry professionals for your active engagement, insightful discussion and enthusiasm throughout these 2 days, hopefully. So your presence and participation will make this workshop a grand success. So I hope the knowledge shared, connections built and ideas exchanged during this upcoming 2 days program, it may inspire new collaborations, a stronger IP awareness and meaningful advancement in technology transfer other than other kinds of IPR. So once again, thank you all and we look forward to more such interaction in the future. Thank you.
Thank you, Pankaj sir, for the vote of thanks. Now, I would request everyone to proceed to the snacks area. We'll be having a short tea break. Thank you.
कोई दिक्कत नहीं, हम लोग का टाइम है ना, हो जाएगा, हमारा बस भी रहता है, ये बस हम चलते हैं। और अभी क्या करें?
হয় 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 আপুনি এনে থাকে ক'ত?
360 থাকলে তো আপনাকে কেন লাগে না?
Chair for Hannah. Chair for Hannah.
You have to click something like this.
Chair for Hannah.
Chair and I.
ये गड़बड़ हो गया।
सर हम लोग भी आपसे बहुत खफा है,
हाँ।
आपसे बहुत खफा है सर। सर 6 years आपको पता है? आपको पता है 6 years of experience in anchoring। ये हाल है? सर फेलिसिटेशन कितना इधर उधर हुआ, आप खुद ही बोलिए। अब क्या बोला है? आपके कुछ बोलने हैं? कुछ हो गया? आप अभी बोलने हैं? आपने बताया नहीं। कुछ इंट्रोडक्शन से कुछ गड़बड़ हुआ है कि नहीं? बाकी तो सब ठीक है। फर्स्ट तो उनका है टेक्निकल सेशन उधर से, पहला उनका है उधर से, और तो बाकी कुछ गड़बड़ नहीं हुआ है सर। BL भी
different districts. I'm looking at Yoga, choosing
I think there are 4 main symptoms. It's a bite.
There is also delicacy. Pickle has also come out.
So that we can use it. You grow it, right? So, but still we can use it.
How much is the content we don't know? Yeah, we can research.
Because there are so many other.
Yeah, they don't say given any good result. They have been working in language and a lot of research have been done. No, sir, we have got some scientific knowledge, but actually, sir, what about the farmers? They are practicing traditionally, so they don't want to adapt the scientific methods. We have one very advanced problem, but still they are telling them no. This the scientific methods. Even the plants and mindset.
Even the plants and so on. The things that have a traditional way.
Sometimes the series also provided from samples and crops. So there are some technical varieties, there are some diseases, it's not successful. So they think that they personally, whatever they are preparing, they will go through the problems of this. Assam only, মই ইয়াতে আছোঁ ছাৰ জুডিচিয়েল একাডেমীত আহিছোঁ ট্ৰেইনিং নহয় আজি আৰু কালি ছাৰ একদম মোৰ কালি অৱস্থাই নাই ছাৰ আপুনি আপুনি গ'ল নেকি ছাৰ বাইদেউ অঁ দিলে মানে চাচাটো দিলে বাইদেউ লগ পাইছে হ'ব ঠিক আছে ছাৰ আপুনি যাওক তেতিয়াহ'লে গম পাইছোঁ যাম কথা পাতি ল'ম আপোনাৰ লগত কথা পাতি ল'ম ছাৰ আমি মিলাই ল'ম সকাম কোনদিনা হ'ব ছাৰ অহা শনি ৰবি ঠিক আছে দিয়ক যাম তেতিয়াহ'লে অঁ হ'ব দিয়ক শুকুৰবাৰ থাকিম আৰু শনিবাৰে ন হ'ব দিয়ক শনিবাৰে থাকিম দেওবাৰে শনিবাৰ দেওবাৰে শনিবাৰে যাব পাৰিব
workshop. The first session shall be delivered by our in-house DPIIT-IPR chair from National Law University and Judicial Academy, Assam, Dr. Pankaj Kumar. Sir shall be speaking on the topic IPR differentiation and patent pre-filing requirements to grant. Can we please have Dr. Kumar sir on the dais? Sir, please, over to you.
Thank you. So welcome again. ठंडा बोले तो कोका कोला. Similarly, whenever we talk about IPR, generally the word patent comes in our mind. So there are different kinds of IPR. We have announced 10 IPRs. WTO suggests 7 kinds of IPR like copyright, trademarks, patent, industrial design, geographical indications, layout design of integrated circuits. Other than that, there is a plant variety rights, traditional knowledge, biodiversity, utility models. So this is more than 10 kinds of IPRs. So this is a recent news. See the importance of IPR. How IP can be considered property, because there is some difference in property and intellectual property. There is some misappropriation of data and information related to intellectual property, and they get compensation out of SC/ST Act. So they convince, in fact, it's easily proved that all such data and information is so precious to them. So the value, they get compensation 127 crores for their IP assets. Although not legally protected, still this is a property. See another case. Delhi High Court restrained a journalist from using Ratan Tata's name. So many times people use others' brands, others' goodwill, others' face, others' name in order to commercialize their goods and services. So this is unfair. Nowadays there are so many IP issues, and so the litigations, we have 3 specialized IP courts, one in Mumbai, second one in Delhi, and third one in Calcutta. This is yesterday news. There is an office of CGPDDM, Controller General of Patent Design Trademarks, that is in Mumbai. Although there are different IP offices all over India, like 4 patent offices, there are 4 branch offices for patent, Delhi, Mumbai, Calcutta, Chennai. We have single design office in Calcutta. There are 5 offices for trademark, Delhi, Mumbai, Calcutta, Chennai and Ahmedabad. So they are trying to shift CG office only, the headquarter, Mumbai to Delhi. Still there will be IP office in Mumbai as usual. But see the war on Twitter. So many times, most of we people, mainly the practitioners in this field, IP, have such type of experience that someone asked, we need patent for our logo, we need to copyright our trademarks. Such kind of expressions there is. That indicates that IPR is an umbrella term, so there are various terminology, expression, different types of IPR under the IPR. So all such terms have some different meaning. They are meant for some particular subjects. We can't use such terminology as a synonyms. So most of the times we see people use such a way, like all I asked was, can I patent my copyrighted trademark? So in this sentence, the person used 3 types of IPR, although the subject matter for all such IPR are different. Invention, this is the subject matter for patent. So these are different kinds of IPR, and there are some overlappings in some IPRs like patent and trade secrets, copyright and industrial design, trademarks and geographical indications, you may find some overlappings. Types of different kinds of properties. In first sets you see designs, artistic designs. So we are focusing here on aesthetic aspects of any article, not about the functional aspects. So it may be anything, like your stationery item, furniture, it could be any article. Next one is literary items, literature, drama, music, artistic things, performance, performing arts, broadcasting. Next set of property includes geographical indications, GI tagged items. Every district have many GI tagged items and there are huge potentials. See, right now we have around 650 GI tagged items all over India. You may be surprised that China have around 10,000 GI. And some other countries also have similar numbers. In fact, India have potential of over 50,000 GI. Even Northeast only have potential more than 10,000 GI. So there is an ample scope for GI protections. Every district have many such items, and there are so many potential GI products which yet to be applied. Similarly, there are marks. Everyone in trade and commerce need to sell their products, their services. So they need some marking over their products, their service, so that users, consumers, public can relate such kind of goods, services, the origin, from where such kind of goods and services are originated, the linkage with the proprietor. So mark can be anything. Mark can be your name, your surname, your face, your signature, tagline, logo, device. It could be anything. Layout design of indicator circuits. See your smartphone, laptops. Nowadays there are a lot of things needed such indicator circuits. So there is a unique design. Such design is also protected under this system. New plant varieties. So there is a separate system to register plant varieties under PPPFRA, protection of plant variety and farmer side. Inventions. So there is a difference in invention and discovery. Discovery can't be patented. There are certain criteria to get protection for all such different kinds of different properties. So once such properties qualify such criteria, they can be considered for such particular intellectual property rights. So this concept is not new. In long back, there are different systems, some sort of IPR we can say. So there are some myths. Not sure whether this is a fact or not. There are so many monuments, Nolakha mandirs, ancient buildings. Many times we heard that such artisans either have been killed or their fingers have been chopped, so that no such monuments may be created later. So they have their own identity based on such monuments. Shah Jahan linked with Taj Mahal. So if there are 10 Taj Mahals in different states, there is no such importance. And that's why even Kautilya Arthashastra mentions that if there is a person who invests their time, energy, efforts to create something useful for the society, such person must be compensated. They must be recognized. They must be have some monetization out of all such efforts. Otherwise, there is no any motivation. No one will do such investment efforts for expression of their ideas, because it's not so easy to express your ideas in successful products. And once you do it, everyone are interested. Most such commercial entities interested to copy such products, such technology. So there would be no any motivation to the genuine person, authors, creators, inventors, and that's why this system needed. So this system is a balance. Actually, this system creates a balancing of the interest of the person who invent, design, innovate, create something new, and the person, people, and the users, customers. So they others not to do such commercial advantages out of others' innovations, other creations, and after expiry of such timeline, all such protected things comes in free public domain. Any person interested can manufacture and commercialize even without any permission. So it creates a balance. So see, innovations to a startup. There are so many startups. Legally, a startup means not any person. If I start some business, they can say a startup. A startup are those companies who have recognized from DPIIT and having DPIIT startup certificates. There are some benefits out of all such startup certificates, and there are other schemes like MSME schemes. If you have Udyamada, you may get such benefits under Ministry of MSME. So there are so many schemes related to innovations, creations, investment in research and development. Most of the times all the startups comes under MSME, but all MSME are not startups. So to make a real impact, we need to prove something unique, so that you make your own identity, you may create your own brands, and such creations and further value additions obviously useful to the society. So exclusive commercial usage. So we don't say monopoly. Many times people say monopoly. If you do such IPRs, having such rights, legal rights, you can do monopoly. Actually, monopoly is a negative word. We better use the word exclusivity. That means legally we can exclude others who are not authorized by us. So if a person interested to commercialize others protected things, they need a prior consent. So this is a property. It's up to the proprietor whether he willing to give their property to someone else or not. Or if they may give it like a gift, or they can abandon, they can resell or resell. So they are just like property. It's up to the right holder, the owner. So IPR protected innovations give competitive edge to any person. How it competitive edge? To compete with others. So you have legal rights so that you can restrict others. So that by virtue of that legal rights, you have a competitive edge. So monetization to innovations. Get paid every time someone reproduce your expressed ideas. That is your creations, your innovations. Maybe it's an invention, maybe an aesthetic design of any goods, maybe your brands, literary items. It can be any kinds of such intellectual property. So problem arises once printing press came. So now it's very easy for someone to make a copy of such manuscripts. So it realized there must be some sort of strong system of IPR so that the authors may have rights. So there are some international arrangements. Paris Convention for Industrial Properties. Generally, other than copyright, other kinds of IPR covered under industrial property, and for copyright there is the Berne Convention. Later on, all these Paris Convention and Berne Conventions merged and come in form of WIPO, World Intellectual Property Organization. This is now one of the United Nations body, and we have WTO TRIPS, and all the member countries need to comply such guidelines. So India, being a member of both WIPO and WTO, have these 8 kinds of IPR. In India, this is the IP system. There is an office of CG, Controller General for Patent Design Trademarks, and there are offices. Nowadays we do all such things online, so no need to visit such office, and no need to submit any online documents until they ask. Generally, so far we send original power of attorney, original assignment documents. Otherwise, if they ask some documents, we need to submit. These are the certificates for different kinds of IPR like patent certificate, design certificates, trademark certificates, copyright certificates. This is one of the letter of UGC wrote to all the vice chancellor in India that in view of the importance of IPR, all the university must have some IPR paper like CBCS scheme, choice-based credit system. So all the ranking. All the academic institutions for the purpose of ranking regulated by UGC, AICTE, they need data like how many such IP applications you have filed, how many such applications you have published, how many such applications have been accepted or granted, and how many such applications you have successfully commercialized. So for all such data, they have some marks. And that's why nowadays there are so many applications from academia. So if someone approaches us, he have some innovations how to proceed further. For which kinds of IPR? There are so many IPR, so how we may help them? So everything comes from ideas. This is intellectual property. Intellectual property comes from your intellect. So you need to express your ideas. So ideas may be expressed in different forms, different kinds of intellectual property. Like you can express in the form of artistic things, some design, aesthetic designs. All such comes under industrial designs. So there are some overlapping in industrial design and copyright. We will discuss. Inventions. If you invent something new, maybe a product, maybe a process, that may be protected under patent system if fulfill the criteria for such patentability. Similarly, if you maintain some quality or create some identity for your marks over your product or service, such type of marks you eligible for trademarks, and there is no any conditions like whether you prove novelty or you have some prior usage of that. All is good. If you use such marks already, then it's easier for acceptance. Otherwise, even if we propose some marks, no problem. So can you guess what are such items? To see the unique design of some articles, even if we don't use any color, any name, even by watching such design, the shape of the article, we can recall what kind of such products. So this is the power of branding also. And this is due to the uniqueness of the designs which they making continuously since long, consistent use. So there are so many articles. So it doesn't mean that if some articles already exist, you can't patent any further value additions or innovations. For every such technical value additions or innovations, we can claim further. For every different innovative designs, aesthetic look, we can go for industrial designs. So there is ample scope to claim your creations, your innovations in existing things also. See, biscuits already available and this pen drive is already. But the use, the unique applications of such design for such kind of articles. So this may be covered under industrial design. So there are so many products. While the functional element of a bottle don't generally differ significantly from product to product, its appearance is likely to be one of the major determinants of success in marketplace. There are so many chairs. Functional aspect is same. Only difference is their aesthetic look. Why we prefer better look, a same product, same function with different and better aesthetic look, aesthetic design. Many times people willing to purchase such type of aesthetic design products at premium prices. Same utensils, having the designs, colorful, you may have premium pricing for it. So see, even some such minor innovations, you can enjoy IPR. You can exclude others if you have legal rights. It may be a two-dimensional, it may be a three-dimensional. So when companies are competing at equal price and functionality, design is the only differential that matters. Same function. Only the variance here is design. But the impact 70%. For overall costing of any products, you see it's hardly 5% for design aspects. But the impact, user choice, they prefer, they decide, and 70% impact just due to the aesthetic look of that product. There are many products which are patented, and just due to their design parts, sometimes even not having aesthetic look, but they are new. First time, there are some inventions. So these are some particular goods. So no one tried, even to notice the particular functional aspects, even for the design parts, they are interested to claim industrial design rights in their parts. This is one of the agricultural tools. This is another agricultural tools. So most of the times we may find similar kinds of articles in the market, but still there are some changes. For all such new changes, we can claim industrial design. Many times we experience, if we offer someone for tea, आधा cup, not the full cup tea, half cup. So just imagine, already most of the people talk in that way. If we offer such type of article in market, don't you think there is a huge commercial viability? It's aesthetic, it's too aesthetic, and there is a linkage with this half cup. So now you can serve full cup in this half cup. These are some of the examples state-wise, and all such pictures came from this Assam state, like Assam tea, Tezpur lychee, Karbi analog ginger, Assam gamusa, Kaji nimbu. So all these are different kinds of intellectual property protected under different kinds of intellectual property rights. See the brands, once any brand is famous, like well known, having some well knownness, many times people try to use such keywords, make their own deceptive similar kinds of marks to offer such goods and services. So there is a life cycle of all IP. We have to create first, we need to protect it, we need to maintain it, and again, out of all such recognition and monetization, we can reinvest our such further energy and invest fund for new creations, new innovations. So if we talk about patent, there are three criteria we need to fulfill: novelty, inventiveness, and utility. See the definition or the meaning of patent. This is an exclusive rights, exclusive, granted for an invention. The subject matter here is invention. So which is a product, maybe a process that provides in general a new way of doing something, non-obviousness, or offer a new technical solution to a problem. So these are the criteria which is already mentioned in this definition or the meaning of invention or patent. So section 2 of the Patent Act defines invention. What is an invention? So if you see the definition of invention, you see a new product or process, that means a novelty. You need to fulfill novelty features of your inventions. Your inventions must not be anticipated by earlier publications. Although in last year, Rule 2024, under Form 31, you can request for consideration of 1 year timeline for such anticipation involving an inventive step. So your invention must not be obvious, it must be everything have certain uses. So we hardly have any problems with this third criteria. Most of the times, whatever the objections we see in the examination report issued by Patent Office, objections relates to novelty, inventiveness, and most of the times the focus is to differentiate your work from others' work. There are some citations like patent literature citations and non-patent literature citations in the examination report. We need to differentiate our work from the cited work. And other important point that is covered generally, the drafting. So issues relates to drafting, particularly the claim parts. So many times we need to redraft the claims. So inventing and patenting, while carrying out research or project, we need to identify some problem. All such patents for inventions are some sort of solution for technical problems. So we have to first find out some technical problems, some problems for which we can provide some solutions. If we provide some solutions without any problem, generally there is no any value. This is novelty. This is so easy to understand. New. It must be new. So it is suggested that publish and perish, patent and prosper. Earlier Director General of CSIR, Dr. R.A. Maselkar sir, suggested to motivate their scientists, if you publish your research and development work, then you can't claim patents. Anyone can use it. You can do it such publications even after filing the patent applications. So better file first applications, then you disclose, then you can publish it. Regarding the inventive steps, as per the Patent Act, it means a feature of an invention that involves technical advance as compared to the existing one. Whatever already exists, you have to provide some advancement, or either this or what next, economic significance. You have to make such things more cheaper, more economical. So if either of these two conditions fulfilled, it's okay. And both Sone pe Suhaga, if you have both technical advancement and economical advantage, it's great. And even after fulfilling all these criteria, you have to fulfill this one, and that makes the invention not obvious to a person skilled in the art. So they are listed under section 3 and 4 of the Patent Act, what cannot be considered inventions. So forget patent. So this is the step in patenting. We have to do analysis whether this comes under patentable criteria or not, whether such things fulfill patentable criteria or not. After that, we need to arrange some patent specification. Then we may go for patent filing. There are options, online and offline filing. Most of the times we people do only online filings. There are 10% discount also. After that, there is a publication. There is a default publication after expiry of 18 months. If someone requests for early publication, that will be published within 1 month generally. And then there is an examination process. This is not optional. We have to request it. Earlier there is a 4-year timeline. In last year amendments, Rule 2024, there is a 36 months. We have to request for examination. And finally, it disposed based on the merit. So there are some databases. Most of the databases are free. Google Patents database is one of the free database. Every country have their own national database, international database like Patentoscope we can use. So these are the minimum documents for filing patent applications. Form 1, Form 2. Form 1, that is for title of the inventions, name of the applicant, name of the inventors and their contact details. And Form 2 we covered invention disclosure. So these are the minimum documents. Later on, based on the need, we can proceed like Form 9 for request for early publication, although this is optional. Form 18 for request for examination. If inventors are not the applicant, then applicant need to arrange proof of right in their name. So these are some other documents, but all such documents need not be used in all such cases. It depends. This is the IT portal where we may go for any of IPR, patent, design, trademark, copyright. So we can log in it, and after that we can upload all such documents. Later, all other documents. So a specification covers title of inventions, field of inventions, background of inventions, objective of inventions, summary, description, embodiments, brief description, detailed descriptions, advantages. All such are different components of your patent specification, and the most crucial part of this patent specification is claim. And lastly, the abstract. So this is all about the parts of any patent specification. Once they publish, the publication is in this format, one-page document having all such bibliographical information, name of the applicant, name of the inventors, abstract. This is file record. Whatever the document exchange in between applicant and the IP office, all such document you can access it. Anyone can access it. This is in public. So there are total 21 fields of subjects which considered for patent, including agrochemicals, biotechnology, chemicals, civil, communication, electrical, electronics, food. So this is overall examination process for patenting. First we have to request for examination. There is an examination report, first examination report, first FER, that means maybe subsequent examination report or second examination report. So we need to respond such examination report within timeline, that is 6 months. And once we apply based on the merit, if they convince, may be considered, otherwise there may be a requirement of hearing, and based on the merit of the applications either accepted or rejected such applications. So this is a patent certificate, and this is a certificate of inventorship. Many times only the applicant name is mentioned in the certificate of patent, and inventors, in order to motivate the inventors, they can request as per the amendment rule 2024 their own certificates. So all the inventors can request separately. This certificate will be issued by the patent office separately in the name of all such inventors. The government fee is 900 rupees. So these are some of the granted patents. You get the notification by email and their certificates. This is the government fee, 1600 after discount of 80%. The government fee is 1600. If you need early publications, you have to pay for such a publication. The fee is 4000 rupees, 2500 rupees, and for the examination the fee is 4000 rupees. This is the discounted 80%, otherwise the charge is 8000, 20,000 and 12,500. So there are some schemes like Kapila scheme, DISC scheme, SIPP scheme, MSME schemes, under which you may get reimbursement and advantage of free IP facilitation service of IP facilitators. So there are so many questions related to patent. These are some FAQs. We can't cover due to paucity of time. So thank you very much. You may interact during the breaks if we need some further information. We have further sessions on GI, copyrights, traditional knowledge. So you can see in the slides there are multiple IPR can be clubbed for single items. So there are different aspects of any articles, like aesthetic aspects, one thing, functional aspects, different things, brands, different things. So all such different aspects can be protected differently. So in this जिंदगी के साथ भी जिंदगी के बाद भी aspirin, this is a brand name called acetylic salicylic acid that is invented by under the Bayer. So Bayer patented it. Patent life cycle is maximum 20 years. So after patent, still they are enjoying the brands for this aspirin. Nowadays, anyone can manufacture this acetylic salicylic acid, but no one can use aspirin. They can use different brands like Dispirin or something else. So by such means we can say, even after patenting, you can enjoy the IP rights in the form of branding trademarks. We have different rights for domain name. Domain name and trademark is different. So be innovative, think outside the box, produce original work, don't buy back to promote IP culture in the country. There are huge career prospects, huge job opportunities in this field. These are some of the useful links: CPM, DIPP, CGP.
Thank you very much, Dr. Pankaj Kumar sir. We are truly grateful to you for delivering such an enlightening session on intellectual property and transfer of technology. We sincerely appreciate your time and effort in enlightening us today. Thank you once again, sir, for your remarkable contribution.
To begin with the second session, let me please welcome on stage Mrs. Dolly Kumar. Mrs. Dolly Kumar is presently working as a research assistant in DPIIT-IPR chair at National Law University, Assam. She is also a research scholar and currently pursuing her PhD from PG Department of Law, Guwahati University. She has completed her 3-year LLB in Intellectual Property Law from University Law College, Guwahati University in 2013. She has also served as the guest lecturer in PG Department of Guwahati University. Today, ma'am shall be delivering an overview on the geographical indications in Northeast India. Kindly welcome her with a big round of applause. Ma'am, over to you.
Good afternoon, everyone. I welcome you all to our 2 days workshop. Being also the host of the program, I take the honor to welcome you all to our 2 days workshop. So to begin with, I would like to introduce myself. I am the research assistant of the DPIIT-IPR chair in Anuja, and today I will be dealing with the topic geographical indication in Northeast India and overview. So to begin with, I would like to first of all mention about what is geographical indication. So as we all know, so geographical indication, it is an indication which is applied to goods or products. So when it is applied to goods and products, the main thing that is covered under GI is that the indication has to, it has to have a specific geographical origin. So that is the main crux of a geographical indication. So when this tag is given, it has to be from, first of all, it has to have a geographical origin, and secondly, it has to have certain characteristics, certain, reputation has to be there, and certain qualities has to be there. So, and that characteristics or reputation or uniqueness, what is there, it is attributable, it is attributed to the place of origin. If you can see the slide, examples are given of the various GIs that has been registered in India and also world GIs. So by telling that it has to be linked with a place of origin. So here you can take the example, you can see the example, Mysore silk is there, Kurg orange is there. Being from Assam, we can give the example of the Muga silk of Assam. Now the Muga silk of Assam, the uniqueness. What is the uniqueness of the Muga silk of Assam? The golden thread, the traditional golden thread that originates in Assam.
Now if the same cocoon is reared in some other place, it is not reproducible in any other part except in this place because of that distinctiveness which is only found in this region. Similarly, if we take the example of the Madhubani paintings, the Madhubani paintings that is has been registered from the Mithila region of Bihar, so it is distinct. And why that distinctiveness is there? The distinctiveness is due to it is because the artisans, they create it at one go. Now why they create it at one go? Because that is the artisans, they create them spontaneously because they think that it is inauspicious if they redo the paintings again. And whatever paintings they do, it is derived from the natural colors. So moving on, the legislation that in India we know the GI is registered under the provisions relating to various provisions, be the rights, the registration process. We have the legislation, that is the Geographical Indication of Goods Registration and Protection Act 1999. And there under the definition given under section 2(1)(e), will be finding the definition of geographical indication. And that definition says that it is an indication similar to what I have explained just now. So it is an indication and it identifies such goods as agricultural goods, natural of GIs. So the categories of GIs includes, it can be agricultural goods, it can be natural goods, it can be handicraft goods, it can be manufactured goods. So either it has to origin from that place or it can be manufactured. So if it is originating from that place, so it has to be from a territory of a country or a region or locality in that territory. So or even if it is manufactured, in case of manufactured, either the production or the processing or preparation has to be in one particular territory or in a region. So this is a definition which is given in section 2(1)(e). Then moving on, these are the categories of GIs. If you just now which I have said, there are various categories. I have given the example. I will not read that out because I hope most of you are aware only. The various examples from India as well as from Northeast. So it can be categorized under agricultural goods, it can be categorized under foodstuffs, it can be categorized under categorized as handicrafts, textiles, manufactured goods, and natural products. So various examples I have inserted which reflects how the products or the goods from different regions are registered under different categories. Moving on, the validity. So the once it is registered, I will talk about the registration process. So the protection is given for a period of 10 years. After the expiry of the 10 years, again renewal has to be there. So from time to time it can be renewed. So now this distinctiveness, this special uniqueness or characteristics, these are available because of certain factors. Certain factors contribute to such distinctiveness. Now these factors can be categorized under 3 categories. The natural factors, the human and cultural factors, and the reputation and historical significance. So if we see the natural factors. So in natural factors, we see that the climate of a particular region, the weather condition of a particular region contributes to the distinctiveness. Like if we give the example of Darjeeling tea. Darjeeling tea is unique because it has a distinct aroma. Now why that aroma is there, the distinct aroma is there because of the cool and misty climate of the Himalayan foothills. So every region, every product has to have some distinctiveness, has to have some uniqueness, and for that uniqueness, the product will be registered and it will be known to that region. Similarly, if we take the example, the next factor, natural factor, it is the soil composition and minerals, the Nagpur orange. So that Nagpur orange, the black soil of that, now it is not that that orange has been only registered in Nagpur. There are other oranges also. Like in Arunachal, we have the Arunachal orange, we have the Kasimandri. Now all these have their own distinctiveness in their own region. So these are the natural factors. If we talk about the human and cultural factors, then it is a traditional knowledge and skills. Again, I have inserted the example of the Muga silk of Assam, because here the Assamese artisans, they have been using their traditional silk weaving techniques from centuries. And just like at the very first instance, I gave the example that if that cocoon is reared in some other place, we will not be getting that golden thread color in other place. Then the unique processing and fermentation methods, local practices and indigenous techniques. These are the factors which contribute in the human and cultural factors. Then in the reputation and historical significance, we can talk about the cultural and historical legacy, the association with a specific community or tradition, and the global recognition. In global recognition, we can give the example of the Tirupati Laddu. So it has a global recognition. So moving on, now why this GI is important? So GI is important because there are various factors, there are various attributes to this advantages of having a GI product registered as having a GI tag to a product. So first of all, the economic benefits. So economic value, the product will be gaining the economic value. So it increases the market value and demand for local products. And then secondly, it protects the traditional knowledge and culture. Thirdly, it gives legal protection against misuse. Now, if the products are not registered under the GI, then obviously there will be legal protection, and if after registration someone is misusing it, then the registered applicants can take action against the one who is unauthorized using it. Then lastly, it boosts the tourism and exports. Then as my topic is on the GI in the Northeast region, we all know that GI most of the GIs are being also registered from the Northeast region. The Northeast India comprises 8 states. Recently from Assam, many registered there are lots, but I have just incorporated some of them in this slide just to show how products from different states of the Northeast, they have been registered under the GI Act. So just now the example which I have given, we find the list of the GI registered under the GI registry, and I have only taken the example of the recent year because I want to highlight about if you can see the list, Assam's list is there. Recently 8 new GIs have been registered from which depicts the Boro culture. So the Boro Aronai, the Boro Napam, the Boro Onla. So these are the various GIs that have been registered recently from Assam, and it includes the handicraft, the foodstuffs. Mostly they are the foodstuffs, and also the manufactured products. So international convention, I will not be dealing much because these are the important international instruments which governs the protection of the GIs. Then when we talk about the registration of GI, certain methodology, we cannot register a product suddenly. There is a methodology has to be followed. Now, for registering a GI, firstly, we will have to identify the products. Which is obviously, as a DPIIT-IPR, we also have a responsibility if we could identify any potential GI. So the first step or the first stage that comes in this identification of a GI product, the first is a field visit to identify any prominent GI and who are those GI beneficiaries. We have to first identify them. Now how that identification will be done? Obviously we will have to do a field visit. Then secondly, we will have to assess the prominent GI or the potential GI. Then, and we will have to see whether the criteria that are given under the GI Act, whether those criteria have been fulfilled or not. Thirdly, survey and documentation has to be there of that potential GI. Then, we will have to assist it towards the formation of the list of GI beneficiaries. Who will be the beneficiaries of that potential GI? Then, documentation of the historical evidence. Historical evidence is very much necessary. Historical evidence and uniqueness, if it is not proved, then a product can be, refused. It cannot be, because there are various products. We can take the example of our, Assam only, the Sarthebari bell metals. Because of, or we can also take the example of the Lakadong turmeric, where the product, the community, they were not able, or society, they were not able to provide the historical evidence, as a result of which, at first, at one go, it was not registered. So historical evidence and uniqueness has to be proved. Then after this, the preparation of the GI application comes. So filing, then the filing, I'll mention about the very briefly. I'll mention about the steps of GI application. So filing of the GI application at the registry, GI registry. Then scrutiny will be done by the GI examiner. Then addressing if any objection is there about that product, about that potential product, and obviously the objection can be made. Notification of the acceptance in the gadget. Then if it is no objection is there, then obviously within the statutory period of 4 months, the office of the GI registrar will proceed to registration. And if there is means the steps are there. I'll just show you the steps, the 10 steps which will guide the registration process. So first of all, the filing of the application, the preliminary scrutiny, the constitution of the consultative groups of experts. Experts has to be there, a constitutive body has to be there who will look into the various aspects of GI. Then the examination will be there, show cause notice, the publication in the GI journal. If we visit the GI registry, we can see, the documents, what are the documents that was provided. We can see it has been attached, all the registered GIs, you will find the sets of documents that were produced. Then opposition, if it is there will be opposition, then registration. Even after registration, there can be appeal, and obviously the protection will be given for a period of 10 years after the expiry, again renewal when the applied. Then the documents which are required for GI registration. So these are the details has to be given, address has to be given, form is there. All these are there in that the case whoever will be the potential the applicant has to submit all these documents. So this is, I will not explain so much in details. This is the one which I was telling. This is the flow chart which shows the registration. Now, who can apply for GI application? So, obviously an association of persons or the producers. So, in the methodology I have the first step that I will mention, that we have to do a field visit in order to identify either the product and or the beneficiaries. So the producers or the association of person has to be there who will be filing an application for GI. So, and they will have to fulfill the criteria which is there under the GI Act. Now, here the concept, two concepts is there. One is the registered proprietor, the other is the authorized user. Registered proprietor will be the one who will be applying for the product. Okay, like for Muga silk we have Aztec. Okay, so in many of the agricultural products we have Meramec. Okay, so they are the applicant, the registered proprietor. So they are known as the registered proprietor. So this registered proprietor will be applying for the product. Then after this, who can use this product? This product can be used by the authorized user. Who can use this? The one who will be authorized. So authorization has to be there, and who will be giving that authorization or the consent? That registered applicant or the registered proprietor. So there comes the concept of authorized user. So applicant can be one, but authorized user can be many. So I'll just show you, after this I'll show you what initiatives we have done. I'm just left with a few slides. So here, because only filing the application, only getting a product registered is not enough. Yes, we have to identify the products. We'll have to, if we can contribute towards facilitating the registration of a product, that is good. But even after registration, what is the post-GI the scenario? Because people are not aware. Even after getting a product registered, only getting a GI tag is not the end result. After that, how the tag is used, that is also the thing that has to be looked upon. So there comes the concept of the authorized user. People do not know, especially while researching, we have found that people here do not have the concept. They even do not know what is GI. When we talk about geographical indication, we don't have the concept, and forget about the concept of authorized user. Okay. So in case of authorized user will be one who will be claiming to be the producer, and no one can just say that okay, I'm the producer. They have to give proof of that. I'll show you the documents that has to be submitted for proving to be a registered, to be an authorized user. These are the documents which has to be required. And for being an authorized user, very minimal fee of ₹10 has been is to be deposited. Affidavit has to be earlier submission of affidavit was required. Now affidavit is not even required. So they have to show the statement of the case. They will have to give documentary of evidence that they are the producer. They will have to show just only, and that certificate has to be given from the person who is known in that place. Then consent letter has to be given. Because here again comes the role of the registered proprietor. The registered proprietor has to give the consent. If the applicant doesn't give the consent, then authorized user cannot show their, they cannot use that, or they cannot apply that product, that tag. And then the filing of the application can be made either in online or offline mode. So, talking not much about the whole, technical concept or the legal aspect from the GI Act, I would like to mention some of the initiatives that we, as the DPIIT-IPR chair of Nanuja, have been taking. In we are also trying to look out for some potential GIs, if we could, from our region. But at least we are trying to help the registration of authorized users. At least the products which have been registered, at least the beneficiary, the authorized, at least the people who are associated with it, at least so that they can get the beneficiaries. So we, with the help of STEC, with the collaboration of NETFI and also the Sericulture Department, we have been, arranging awareness camps, and we have been, the awareness camps is mainly for the registration of the authorized user, because we have seen that, basically our target was, as of now, was for the Muga silk of Assam, because we have identified that here people, although, product is registered, but people are not aware what to do after registration. So we have, we have organized help the people in filing applications for authorized users. And we have for that we have done pilot study for Muga silk, for identifying the Muga silk authorized users. We have arranged camps. Then we have done registration. We have helped them with the registration. And we were very shocked to know that people, even who are working for like Muga silk, they even don't know to put their signatures. They come, they give their thumb impression. But they are working for, they are associated with cultivation, they are associated with weaving process or any other process in that Muga silk, that cocoon rearing and this in Dhupakhana, but they are not aware what to do for being an authorized user. What will happen, whether they can what will the benefit if they get that authorized user certificate. We have also successfully, I'll just show you the figure, till now with having our chair professor with us, we have arranged camps, and till now we have almost filed around 301 applications. We have filed, and till now the registered applicants and the certificates distributed are 53, and still certain applications are in process, and we hope to distribute this pending GI certificate, authorized user certificate, in this coming year. So these are the initiatives, and these are some of the snippets that we have from our awareness camp that we have organized in collaboration with the various government officials and the especially with the registered proprietor STEC. So that's all. Thank you for such a patient hearing. Thank you so much.
We sincerely thank Ms. Dolly Kumar ma'am for sharing her knowledge and perspective with us today. Your thoughtful reflection have significantly enhanced our understanding and have provided us meaningful takeaways. We are truly grateful, ma'am. Thank you so much for your valuable presence. With that, now let's proceed towards the third session of day 1 of the 2-day workshop. Before we begin, let me take this honor to introduce the resource person for the day. Dr. Sharmishta Barua is presently working as the Research Officer as DPIIT-IPR Chair at National Law University, Assam. Prior to that, she has been working in capacity of Assistant Professor of Law at University School of Law and Research under University of Science and Technology, Meghalaya. She has conducted several IPR webinars and seminars and conferences under the aegis of DPIIT-IPR Chair and has also delivered on various IPR topics in several FTPs, training programs as well as webinars on online and physical mode. Ma'am, today we will be speaking on the copyrights on academics. Kindly welcome ma'am with a huge round of applause. Over to you, ma'am.
A very good afternoon to one and all present here, and I am also my topic was based on copyright in academies, but I can see that a lot of you are from the scientific background, right? More into kind of technical. So I'll try to relate copyright with the technical side also. I mean with the scientific inventions and more so with patents and all. But I hope there are a few of them are here who are also from the academic, academics like research scholars and the students. So whenever I just ask the question to the patent or the patent agents also, I suppose, what is dealing with the patents, right, ma'am? So before going for any kind of patenting, you all just based your patents, based your filing of the patents, to any kind of research papers, right? The research papers where the inventions and all the scientific technicalities are being mentioned there. Am I correct? Right? So those researchers, before they just before the scientific inventions gets the patents, and those things are always expressed in a form of a writing, right? So whenever this method of writing emerges, or just putting your research or putting an idea into the writing format, or any kind of expression, expression, there is where the copyright emerges. There is where the copyright subsists, right? The researchers, whenever or the scientists, before getting the patents, they put their ideas or they put their all their research, the innovations into that paper, right? And that is where the copyright takes place, right? So I will just go on to my slide. Just so the regime of copyright, is also is connected with a lot of field actually. More so with academics also, for the research also. Like I said, before the invention gets patents, patented, it is always published in a research format, right? So the we the academicians or the people or the scientific community persons, okay, we also act as we have a double role to play actually. So where where we also play as a content the creators and the and the content users, right? So as content creators, we have a right to access the knowledge. So before creating any kind of research paper or before bringing out your inventions for the scientific community, you have to take a lot of research work. And while doing that research work, you have to refer to other research work also, isn't it? That is called the right to access the knowledge, right? But while accessing that knowledge, you also have a supreme duty to protect the other person's creativity also. That means you cannot steal someone else's research and just publish it as your own. Can we do that? Will it not be infringing the other person's innovativeness or the creativitiness, right? So in that way, we have a duty towards respecting other person's creativity, right? So here is where, and these two roles are also overlapping also in nature, because the content content creators are also the content users. So the content creation in academic is of course in the form of academic writing and academic research works, right? It may be any kind of research papers, thesis, dissertations, assignments, projects, even the question papers also. Okay. Now, even for the GI also, whenever there is the publication of the particular about the details of the GI in a GI journal, can I directly take it take from there, copy it, and then publish it in my own research paper? Can I do it directly without acknowledging from where I have taken? We cannot actually. This is an infringement of copyright actually. Even for the scientific research papers also, nobody can steal others' ideas and just publish it in your or my own name, right? So now the copyright strikes the balance between this thing, between accessibility and between protection actually, right? So copyright, many people are under the impression that copyright is only for the for the other sectors, not for the scientific people. No, it is equally applicable for the scientific community as well, because the scientists publishes their own research papers also, right? And there is a lot amount of then also for the musical compositions, lyrics, musical compositions also, right? And for the artistic expressions also, which includes photographs also, we come to subject matter later on, and for the cinematographic films also, and for the sound recordings also, for a limited period of time. And after that particular term ends, it just enters into a public domain. Right? So for copyright protection, these three things are very much essential. The first is the work must be original. Your work must be the original. Okay. Now the originality does not mean the 100% original. Of course, you have to borrow from others' idea, but you have to acknowledge the other person's work from where you have borrowed. This is applicable for the scientific research papers also. Okay. I'm saying the word scientific because there are a lot of people for the science fraternity also here. So then the work must be fixed. That means it must be represented in a tangible form. Like I said, the copyright does not subsist in the ideas. It is in the expression of the particular idea. Okay. And the last is a minimal creativity. That means it doesn't mean that the level of creativity or the innovativeness must be this high. It can be just minimal also, but it must be original. Okay. So now the basic purpose of copyright is to encourage creations and plus dissemination of the knowledge. That means in order to create, in order to protect all those creations, one cannot stop from the dissemination of knowledge. You have to give access also, and at the same time protect also. Okay. Then, like I said, these are the subject matter of of copyright, where the literary work it just pertains to all other things which are the research papers and all these things. Then the paintings, of course. Then the photographs also. Then the drawings, yes, drawings can also include any kind of schematic design of an invention also. Before putting out, before just going into that, what you say, that particular invention into the form, it has to be just made into a design. Then the model. Upon all this thing also, copyright subsists. If I am not wrong, even on the model also, copyright is there, right, sir? Along with industrial design for the model, right, sir? Then only the patent can come into existence. After this, everything is done and the invention is put in place. Then you have to take the right over that invention, right? Then the films, of course, music. Then even for the choreography, then for the sculpture and all this. And these are the extended regime of copyright. Also includes these neighboring rights, which are which are for the performers also. Like like Amitabh Bachchan's very unique voice has been copyrighted because he has a very unique way of saying. Then Shah Rukh Khan's landmark, that expression, right? It is also copyrighted because no one can do that thing except for him. Of course, we can act like we can just copy. There's something different, but you cannot keep on repetitively use this expression everywhere. Then you have producers of the sound recordings and the phonograms. Then the broadcasting organizations also nowadays have their own copyright. Broadcasting organization means those organizations which cover a lot of channels, right? Then this is a term of copyright in India under the Copyright Act of 1957. It's for the lifetime of the particular author plus 60 years after his or her death. And after that, after this period expires, the work comes into the public domain. But coming into the public domain does not mean that you get a free hand to take the work and just leave it to be your own. One has to acknowledge the original author actually for everything, right? But for the performance right or for the extended version of copyright, for the neighboring rights, it is only 25 years this term. Okay, now copyright is the only IPR where the term is for a very longer time, extended duration, right? Then whose rights are protected? Of course, copyright protects the rights of the author, or the authors, or the creators, and the person who creates the work first is the first owner of the copyright. Now, why am I using the word first owner? Because the copyright can be assigned also, can be transferred also. In that case, it becomes the second owner or the third owner. Your employer shall get the copyright because it was during your employment only. Now, suppose if a scientific office has created any kind of has taken out any kind of research publication in the course of the employment and under the authorization of the employer shall get the copyright, shall take the copyright over it. Okay, so I'm not just deal with all these things. So there's a kind of work, and the first owners here. Like for the literary or dramatic work, authors are there. For the music work, composers are there. For the artistic work, other than photograph artists and a photographer, etc. Okay, and even for the software also, software is been copyrighted in India. We still do not have the software patenting thing here. I think in the US there is this the software is been patented, right? So I do not know much details about what are the technical nitty-gritties of software patenting, but here in India, softwares are being copyrighted. Then we have, I will not deal with this too much. These are status of copyright, where there is no single international copyright for all. All countries have their own copyright laws compliant with the international conventions like the Berne Convention,
UCC, then the TRIPS agreement, okay? Then also there are this WIPO copyright treaties are there, then the WIPO performances and phonograms treaty. Then the third one is the US based law, Digital Millennium Copyright Act, okay, which is more for the digitalized versions of publications and any kind of works. Now the Indian Copyright Act is originally of 1957, and it came into effect in the year 1958, and thereafter it has been amended several times, of which the latest amendment was in the year 2012, which is the most significant and the most substantial amendment, because it just complies with these two treaties, WIPO treaties actually, and it brought the digitalized version of copyright into India, where you can protect your work in the any kind of digital platforms actually, like the YouTube and all. Then a concept of open access in the internet. These all things came into existence and their protection thereafter. So this was been introduced by this 2012 Act. Now I'll just speak on the rights. Now what are the important rights of the copyright owners or the copyright holders? Two important rights: economic rights, and the second is the moral rights. So these two are the very significant rights. Now under economic rights, when like I said about the first owner or the second, third owner, whenever the first owner assigns his or her right, you have a right under the copyright, where you can assign your work your work to a third or a fourth party, third party, but under an agreement actually, where you be getting your royalty also, right? So under the economic rights, you can just reproduce or make copies of your work, or you can just distribute among the public. Then you can sell, rent, or lend it to someone. Then you can display it in front of the public. It is your choice, because you are the creator or the author of the work. Then you can adapt it, or you can also translate your work into some other language. These are all your rights, being the author of the work. And you can also make it available on the internet to be freely accessible by others. Now, but for moral rights, the moral rights are these two very important concepts here: right of paternity, where the author has a right to be acknowledged. Whoever takes his or her work, the person has a right to be acknowledged, right? And the right of integrity. That means the author can object against any kind of mutilation of the work. If somebody represents your work in a very damaged form, distorted form, the author has a right to take an action against that particular person. So, but here these economic rights are always transferable rights, because by mode of assignment or by mode of licensing. But the other right, moral right, can never be transferred. Even if your work has been transferred to a third party, but your moral right assigned, but the moral right always lies with the author, right? So this was the first case of the moral rights concept which was recognized in India in late 1980s. So I'm just giving you this basic idea of copyright. So then is copyright registration mandatory? No, it just comes into existence automatically once you have just created your any kind of creative work, any kind of research work. When you just put it into the expression form, writing, okay, writing maybe or like any kind of recorded version, whatever. So it comes, your copyright comes into existence in that moment itself. But to get a better protection for your but to get evidence of registration, evidence of copyright in case of any suit, in case of any case, the registration, that particular certificate of registration acts as a prima facie evidence of your being the owner of that or of your being the copyright holder of the particular work. So, okay. Otherwise, registration is not mandatory. It just comes into play automatically. Now, when does the infringement take place? Now, whenever any work, any reproduction of work, any kind of illicit activity connected with the use of any copyrighted work without the author's consent, or without the copyright holders consent, it amounts to infringement. So infringement are all these things, any of these things, making the infringing copies for sale or hire, for permitting any place for any kind of illicit performance without the authority, without the author's express permission, for selling of the books, any book without taking the publisher's consent, or without just buying it, just selling it in an illegal form. All these things, public exhibition, then the importation of the infringing copies to other countries, right? These are all from other countries or to India, import and export both, right? So these are all under the Copyright Infringement Acts actually. Whatever, any kind of activity which has been done without the author's permission is an infringement actually. Now there are these, whenever infringement takes place, there are also the remedies also for infringement. Now there are three kinds of remedies for copyright infringement. First is a civil remedy, where you can see this injunction orders can be filed, damages can be claimed, accounts can be seized, then the delivery of the infringing copy can be stopped. Then the damages looking for a conversion, okay. Then you have also these are being undertaken by the civil courts actually, district courts, and then we have the criminal remedies, which are in the form of the imprisonments, fines, seizure of the infringing copies, etc. Then also sometimes the administrative remedies are also there, in where the registrar of copyrights has a power of a civil court. Okay, and the person can take matters into hand and then deal with the copyright infringement. Okay. So then we have, yes. Now, whenever the question of infringement comes, now is the use of any copyrighted work amounts to infringement? If you just stop, like I said, access for knowledge. If everything is being protected under the regime of copyright, how will you access the knowledge, right? Now for this thing only, for certain activities, the exceptions are being given. Now this is called the fair use. Fair use means that you can make some amount of fair use of your copyrighted of others' copyrighted work. Fair use means now these are the four elements which can constitute the fair use. Now, in order to constitute the fair use, these four elements must be present. Now, what is the purpose of the use? What is the purpose of the use of the copyrighted work? For what purpose is the copyrighted work is being used? Okay. Secondly, is the nature of the work. What kind of work? For what kind of work is the copyrighted work being used? Second is the how much amount of work is being used from the original, from the copyrighted work. How much amount of work is being used? And third is the effect of the of the use of the work upon the original work. So these four elements are there, and as stated in the R.G. Anand, R.G.
the more like one person copies, the less fair it becomes. So more copying means the infringement shall take place. Okay, but for certain purposes, the fair deal is been applied, and for these purposes, copyrighted materials can be used. Some portion, not all. Okay, just a relative portion of the work can be used. For example, for the purpose of research or for any kind of private study. Then for the teaching, learning, learning purpose. Then for the criticism or the overview. Then for the reporting of any kind of current events. Then etc. Performing to a voluntary performance, okay, to a charitable, for a charitable cause, non-paying audience. Then for any other specific conditions. And like by the way, some government works are also exempted from the purview of copyright in India. For example, enactments, that means act. Okay, then the reports of the committee, commission, council, board, etc. Then the judgments or the orders of the court. These are exempted from copyright. So all these things does not come under purview of copyright. But apart from that, the other things are always under the copyright. Okay, just keep it. Yes. Now I will not give it much with the academic side because my topic was based on the plagiarism and actually all these things which are very much connected with the research work and all. But a little bit of the brief idea. The access to knowledge. Like I said, as being academicians, we have the right to access the knowledge first, right? Now this access of knowledge. Now can all copyrighted work be in the name of education? Can you access everything from the those copyrighted material, everything without acknowledging the author also? That cannot be done. But yes, for the education purpose, it can be done. Why? Only the relative portion can be taken, like for the fair deal case, right? Now, in the case of this DU photocopy case, this was a very significant case where the Oxford okay, and the Oxford okay, and Cambridge publishers filed a suit against these Rameshwari photocopy services because this photocopy services was in the DU campus, Delhi University campus, and these photocopy services used to photocopy the experts, the experts from the very high-priced international authors' books. Generally, the international books are quite high-priced, right? And this Rameshwari Photocopy Center had always used to make the course specs. They used to take out the excerpts and then make the Xerox and then just make it into the course specs so that the students can take it to study. Students and the faculty of the GU can just use it for the research and for the study purpose. But then this Oxford and the other publishers when the matter came to their light, they just arose they just got bursted and then they filed a suit against this Rameshwari Photocopy Center. And they said how dare the particular center Xeroxes our books without our express permission because we are the publishers of the book. But it was then only the right to right of education was emphasized, and they said that those high-priced books, how can the students and the faculty access those, because these are euros and pounds and the dollars, right, which becomes very much high for the Indian academicians to access it. So it was then only it was decided that this can be used under fair deal system, that some amount of important work can be accessed without even considering for the copyright. So this was the access of knowledge first being granted to India under this case, that for the sake of education, copyrighted material can be used, but not the entirety, some excerpts. Then we have open access and copyright, because some research papers you can see also in the open access platforms also. Now open access platforms are the very convenient way to access all research works actually, but there are certain licensing systems there, like you have to subscribe maybe. Some platforms like you have to subscribe to it. Like we have JSTOR. Okay, then we have Hein Online, where there is a subscription amount is to be paid, and
After that, subscription has been done, you can access the things being uploaded in that particular platform, all the research works, right? But you have to acknowledge, right? Then we have is a CC licensing system. Okay, this is one important, I'll just come to it later on. Now for open access to work effectively, it needs to be correctly copyrighted and now open access also gives higher availability and higher visibility also, and it also generates higher citation impact. The academicians will just know it, the significance of citation score for the academicians. Okay, then this Creative Commons is a very easy to use copyright licensing system where in copyright you can see the word all rights reserved. Now under CC licensing it becomes to some rights reserved. Okay, so I will not deal with it much. And then we have the duty towards respecting others creativity, like the duty towards protecting the other work. Access and protection must be balanced, and that's what copyright does it actually. So the public domain work, yes, you can access it. Of course, when the copyright term has lapsed, the work just enters into the public domain. But you cannot borrow the materials without acknowledging the author. What is important is that the copyright says that you must acknowledge the particular author or the particular owner of the work. Okay? Then how much amount of work can be copied, right? Or can be used. This is based on doctrine of insubstantiality, that one cannot use the entire substantial part. Okay, I'll come to the substantiality later on. And then verbatim copy means line to line copy. Of course not. One cannot copy line to line copy. Okay. Now in this case, what happened, or cannot claim copyright also. This was a very famous case of supervisor and a research scholar, where the supervisor insisted the scholar that I want copyright over your thesis. But the court declared that a thesis, okay, or any research work, okay, is a complete result of the hard work of the particular researcher only. And hence, a supervisor or the guide cannot claim the copyright over the work, nor can copy also from that work. Here what happened, the researcher had, the supervisor had taken line to line material from a particular thesis and then published it in his own name, saying that I was the guide of this particular thesis. But no, even being a guide also, you cannot take the researcher's work and then just publish it in your own name. Okay, because the researcher's hard work only has resulted in the thesis. Okay. Then understanding copyright issues in academic writing and research is also important thing for the protection of this. Then the substantiality, how much amount of work can be taken, it depends upon these criteria, qualitative and quantitative criteria. The qualitative school says that which is the heart or the core of the work cannot be copied. Any part which forms as the crux of the work cannot be copied. But another quantitative school, it says that only 10% can be copied. Okay, our Indian system also adopts this. Judicial recommends that only 10% work can be copied. Okay, you can just copy it directly. Beyond that, it will be plagiarism. Okay, so plagiarism is another concept, and I will not deal with it much because these are the academic integrity rules actually. Whether UGC's 2018 regulation says that only 10% work can be taken, the rest will be amount to plagiarism. Plagiarism is this actually. Plagiarism is stealing from someone else's work and just claiming it to be your own, publishing it in your name without even acknowledging the author. That is called plagiarism. And here I can see this 10% under the 2018 regulation. Above that, it will amount to plagiarism. Okay, then it's the stealing of content, wrongful publication, wrongful appropriation of the work as own, and the lack of lack of credit given to the first owner of the work. That is also plagiarism. And it also copyright infringement. Then we have certain mechanisms for checking out how much amount of plagiarism, plagiarized work being taken. Turnitin is there, Urkund is there. People from the research or the academic background will be understanding this Turnitin and the Urkund and all this software. And the Turnitin nowadays also shows you the AI. AI percentage been taken. ChatGPT, from ChatGPT, how much one has taken. That is also being shown. Because most research papers are nowadays being taken, nowadays being written with the help of ChatGPT. This auditing is a very dangerous thing. It will show you that also, how much amount. Now in case of academic research publication, this is not allowed. The use of AI actually. And then could we have? Then these are the penalties also for plagiarizing, right? These are the penalties. Above that, yes, there will be some amount of implications, and then at the level 3, where this similarity percentage is 60% above, the entire work shall be cancelled, be it thesis or be it any kind of dissertation, be it any research paper actually. Okay. And for that also, even the PhD degree can also be cancelled if the work is so much of plagiarized. So this is the intersection between the plagiarism and copyright infringement. Okay. So when you take it without permission and just pass it off as your own work, it amounts to both actually. So with this, I would like to just end my presentation here. Thank you so much.
Can I ask you this?
Yeah, sure.
So it was very nice presentation, very highly informative.
Thank you, sir.
Thank you for that. And my last first maybe we can start from here.
Which one, sir? Shall I just open the PPT?
No, that's fine.
Okay.
So you mentioned about the plagiarism.
Yes.
And it is not that 30% it is problematic.
Yes.
But Turnitin actually shows similarity.
Similarity, right?
Not the plagiarism, right? So
That
what's
is
the
what
difference
we
between?
count. No, we counted that only as a plagiarism, because when there are similar percentages being shown, it shows that you have copied from somewhere else, and sometimes some words are also taken under it.
For example, I'm working in biology, so we have full forms. Okay, many times these full forms also appear as a
Yes,
similarity.
right. I understand.
So
right.
how we can avoid that?
Sometimes
Because
what
it's
happens.
appear like that.
Yeah, that is why if it comes within that 10% criteria, it's fine. Above that, if your other works are also being connected, with the similarity, certain such as phrases or any kind of sentences which you have taken quote unquote, you can just put it under the inverted commas also. Yeah.
So,
but some full forms, like you cannot avoid it. Even for our law also, we have also found the similar things also. And in your research paper, whenever you upload for the plagiarism check, you should remove all the footnotes actually.
Full forms and those, can we remove that full form? And
Not the full form. The full form, that is case. The footnotes I'm saying. All your references, like you have to remove. Sometimes उसमें भी बहुत सारा plagiarism, बहुत सारा similarity detect हो जाता है. But the full forms, like you cannot avoid. So you have to make that, including your footnote. I mean those full forms also. It must be within 10%. That is.
But this 10% is from one paper or the whole.
It shows from which paper how much amount has been taken, and there are sometimes there are certain filtering system also where you can exclude the words, exclude word by 5 words, 10 words. That also those filters that you can use. Yes, sir.
Because that is we can use it.
And you can also exclude bibliography, exclude quotes, like that you can just filter those, and then only you can just.
I am saying that suppose I'm working on cancer. So when we talk about the global incidence of cancer, okay.
The scientific terminologies comes under
the one sentence we write it, how many times we can change it?
I understand that. We also face the same thing sometimes.
Right? And thousands of papers are publishing every year. So it is very, very difficult. Okay. So what I'm saying that the plagiarism is coming from actually this work that is copied.
Directly copy,
that is, I think, because many, this is what my understanding. And if it is not more than 8 words, continuously, then that is not considered. Some journals are saying that, okay. So that is our main concern. Even when we write so many papers, one student write, and another student write, another student write. So many times the similarity just comes.
Exactly. We also face
definitely, sir.
I
also want to add like this.
And so you have to use it. It depends upon your plagiarism softwares actually. Those similarity softwares which you use. there are different versions of a
Yeah.
software. Turnitin will show you lot of things actually, and even the AI also. Whereas Drillbit will not show you the AI content, and the plagiarism also. I think any of you have used Drillbit.
Yeah. Can you?
Yes, sure.
So I have not used that, but what I'm saying that is plagiarism, and see, we are not native English speakers.
Yes, sir.
Native English speakers.
Right.
So when we write, I mean, we have also some our limitations,
I
right?
understand.
Okay, and sometimes I think plagiarism, that word we are misusing, because we are doing some experiment and we are trying to communicate through the papers. Sometimes
That's
we
what I
have to
say,
use
scientific
similarities,
papers.
right? That is happening, and sometimes I feel that many times, suppose in law or like history or something, they are taking the whole paragraph and those kind of things. That I understand that, but we are doing some experiment, like I'm working on some biomarkers for cancer, and when we write it, the biomarker and the studies are different, but sometimes the wording it may come similar to the other. So I think sometimes we are misusing. I think this maybe the law we have to change.
Yeah, because this thing, the word similarity check and plagiarism are quite
Yeah.
but these are used actually interchangeably, but there are different concepts because in a scientific paper like you have to take some words or something references. So in plagiarism what you can do is then you just acknowledge from where you have taken, acknowledge the source. So that even if it shows also in the software high similarity index, you can always justify it.
Even we are working on drug discovery, and in every year for a particular cancer, thousands of papers are coming on drug discovery, and many times the methods are similar. We use
Similar methods.
and how when we write the methods, it may show some similarity to other.
Law on that. The Copyright Act is silent about plagiarism. It only says about infringement actually.
Okay.
Now the plagiarism part has been imposed by UGC only.
Okay.
They said that the plagiarism percentage must be 10%, be it scientific or like be it social science or like other things. Now the scientific community must raise their voice that we are facing this problem.
Yes. That's what.
That we are facing this problem because our use of the methodology becomes same, whereas which is not applicable for our social science paper because it must be different.
Yes.
Right. So maybe your methods might be similar, but the results are different. So you have to mention the things. No. So my suggestion is that you always acknowledge must be done. But about this issue, UGC can only help you. I think.
Sometimes I also change laws from UGC. Some
yes, the UGC keeps on
Yeah.
Yes.
No,
So if
especially the journals
yes,
also.
if a query can be raised, then what can we do? There are, I think, in the website only they may have this kind of raising queries, maybe UGC. So where you can place your query, or just put an email also that the scientific community is been facing this problem of this thing, how to avoid this.
Yeah, great. That's a very good suggestion.
Similarity index and plagiarism both are same thing or different?
These are used actually interchangeably, but there is a subtle difference between them because
most of these Turnitin and DPIIT, they actually show the similarity.
similarity, right?
Problem is
The plagiarism thing is, but like that has been counted as plagiarism.
Yes, that is the major problem.
That is the issue actually.
Suppose I am
So we
also,
also have to say,
suppose I am working on a bacteria, pathogen. Thousands of scientists working the same bacteria in the world.
Yes, the
When we are writing the
possibility
name of that bacteria, it will show the intent and all, it show the plagiarism. But it is not the plagiarism because we have to use that word.
Now what happens? Turnitin shows as similarity. I
Right.
mentioned the word similarity,
That-
but the other software the guy will use. Urkut also shows, I think, similarity. Any of you have used Urkut?
Urkut, yes, we use it.
How does it come? Urkut earlier, now we have just shifted to Turnitin.
Even now they deal with it. I think that the
Will be shows like
most of-
plagiarism or or similarity? What word, which word does it use?
They most have some similarity actually.
Similarity,
That's the
yes.
problem.
But what I have seen actually, if we use Turnitin shows more similarity.
More. Turnitin is a very,
Yeah.
what do I say,
Right now,
acute software.
One paper it shows 20% similarity in Turnitin, but Urdu it shows only 2%.
Yes. Then I have also found, Urdu reduces the percentages.
Because
But Turnitin shows it higher.
Yeah.
Turnitin will detect everything, even those full forms and everything.
Ma'am, I have one question. Suppose in case of your guide without your means acknowledgement, he is taken your thesis part and published your research
what
paper
I
the
said about
same day.
it.
So how to initiate means
So
kind
you
of
might have to suit against your guide, but you cannot jeopardize your relation with your guide.
that is the major problem.
Get your PhD. So there was a case, no?
Yes, I saw that case.
That case where the guide had, taken line by line word from the thesis of his that particular researcher and published it in his own name. And later on, that particular researcher filed a case of, copyright infringement. No, yes, on this one also, plagiarism also, because in your thesis, when the work is being done, the researcher shall get the particular copyright also, right? Because being the creator of the work. Now the guide has to face all those consequences because the guide has taken being a guide doesn't mean that you are the owner of that work.
Yes.
That's the result of the person, of the researcher, the particular researcher's hard work, right? So that is the case. So you have to initiate, file a civil suit, or just complain.
So can I ask you another question?
Sure.
So that's true actually, I understand. But at the same time, guide also contribute a lot to the research, right?
Do you think all guides contribute a lot?
I want to say that actually what is the mentorship? And generally, when a PhD student comes, most of the time we are giving the work, our idea, and they are doing, especially in biology and chemistry, physics and other things.
In
And
science,
many times,
yes,
even in
science
the
is
meetings, we say, see, you have to understand that this is not what I thought when I have given you this work. These kind of things we use it actually. Actually, they are many times in the initial phase, they are actually technicians, and then later in the research, especially PhD means a training, right? And maybe later they use there also, and it is actually a combination of both guide and supervisor that one. Yes, of course, after that, if the guide uses without the, without acknowledging that student, yes, that's not right. See, if I never publish a paper without acknowledging my students or giving them the authorship, and many times,
See, if the guide acknowledgement,
I'm right, sometimes right, more contribute more, but first authorship goes to the student and then senior authorship will be taken with it. There are many times we do it like that. Okay.
The thing is that in the thesis itself, the guide shall be acknowledged only. That when I or I give my full response, gratitude to my guide. Like those acknowledgement page, एक paragraph तो guide के लिए ही होगा. उसके ऊपर भी अगर और acknowledgement चाहिए तो. But copyright, but the ownership you cannot claim. Never in the thesis.
Yeah. But many times it also happened without acknowledge the supervisor student published the guidelines.
No, that is also,
It's vice versa.
contradictory. Yeah, of course, vice versa. That's what I was saying, acknowledging the owner of the work is the most important thing in copyright.
I think the right should lay with the institute.
Actually. Or it is the intellectual, who is intellectual. See, in our laboratory, what we do, we have a laboratory. And the students are, supposed to write each and everything that they are doing. Even if we have the discussion with the supervisor, yes, I have discussed with the supervisor, and these are the things we have discussed. And there is some rule like if they have some new idea about that experiment, they have to write in the notebook. In the laboratory.
Right. So laboratory notes are also, copyrighted.
And then they have to sign and get the supervisor's signature. And if it is entirely new idea, not based on this project, then I say, okay, there is a 190th page, you use it, and then write there, and don't talk to anybody, even your lab members, and come fast to my office, you sign and I will sign, and this is your idea.
So there are lots of,
things we
I
need
thought
to
that
do it.
the scientific community, faces less copyright, but I think you all are, facing much more than us.
I tell my students,
Right
this is
from
your
the
idea, I don't
laboratory
take, I don't want
right
your
from
idea.
the laboratory
But
notes,
it should be
everything.
acknowledged. And
Yes.
do not talk
Acknowledgement
to,
must be
yeah,
there,
do not
yes.
talk to your lab mates, even friends, because they can write it and then come and then say, okay, I'm the first one with this.
Actually, ma'am has said, correctly that the institution has, must take the copyright. Yes, in case of, Gotti University, where, when I have done my PhD from there, I'm supposed to, publish my thesis into a book. But I have to take my copyright consent from the university now. There is a form being given now, so for which I have to pay some amount for the copyright transfer.
But I think that copyright.
That is why, because of all these issues only, this thing must have been done, because earlier it was not there. Very recently, this thing has been done. Only 4 to 5 years they introduced this thing. They even had to take copyright consent from the university.
But there is another problem then. Suppose the university take a lot of time and then they didn't give you.
That is the thing.
So I think that copyright should be, with the student, the supervisor, and the institute.
No, the thing is that the entire owner shall give the particular researcher only, but the acknowledgement must be given to the guide and this one. Guide especially, because the guide has obviously given ideas and instructions there.
Another thing, why I'm telling that in our area, the supervisor bring the grant, and money is paid by the supervisor to the student.
For what, sir? For the research work?
For the research work.
Oh, that's some
It's a totally different.
scientific people have got the
It's
people on a
different,
science
right?
regime is for different.
Yeah, so that's what I'm saying. So
Even for the laboratory, test and all, the supervisor pays them.
yeah, supervisor from the grant.
Up to
to
the
the
other
research. Yeah.
Yes.
So it should not go to an entirely to
Okay,
the
so you have to pay a lot of money to those researchers for the experiments and all. So it doesn't come with this one, students' admission fees and all these things. Okay.
They may pay 5,000 something per year
It's
or
quite different.
10,000. Our
They are
paying 10 lakhs
they
for
are
this
scientific
research.
one is quite different. Actually, it's not here, but for where you done your this one? GU? Please.
Actually, in Guwahati University also, how much I know, all chemicals and all, everything in the lab, if we have to perform, we have to buy our own set. So no, everything
That is
not being
different
paid
in
here.
GU, Guwahati University.
So,
Means some unique chemicals we have to buy. If we need for the research for some, like it's not available in the lab, we have to
Then
buy
you have
our
to
own.
buy. Otherwise, it comes within the admission fees and everything only, right? So yours is private institution, if I'm or a government?
From IIT.
IIT.
So we bring the grant
Okay.
and then,
Okay, for the grants, right? For the grants.
Yeah.
Then okay. So how is it your own money, sir?
no, there is nothing. So the idea for the grant is coming from the supervisor.
Sir is going to full
Yeah,
deeper
I mean,
level
yeah, it's
of
true,
copyright.
This is
The
so-
idea for the grant.
And because it's a lot of pain actually. Like develop an idea and submit a project proposal.
In collaboration with your researcher, with your scholar.
No.
Alone.
Many times it will be alone or with another supervisor, co-supervisor, co-investigator we say. It's
So
not
I
all
think,
with
there shall be the university regulations will be there, which will be, guiding
that
you
is
how
not there actually in India.
Okay, in that case, I'll be silent on it because it will
Yeah,
be institutions
but it was very informative. That is why I was able
but
to
I
raise
was,
this thing.
had I known that, I would have, delved, much deeper into that plagiarism and the similarities. But I thought, most of you are from the scientific background, so you might get bored. But just keep on bragging about the similarity. Thank you so much for the question. It was very interactive, sir.
No, thank you so
Thank
much.
you
It
so
was
much.
very
I
nice
hope
talk.
I could
Really
do justice to
informative.
you by listening to you some advice, but your institutional matter that will be decided by your institution, sir, in that way. Otherwise, the researcher is the
But I think
main author of the thesis actually.
in a country like India, we should have.
Inventor applicant criteria works with patent.
Ah,
Like who should be the
inventor.
inventor and who should be the applicant.
Yeah.
They are all the process belonging to them. All the rights, the entire rights are given to the university in the form of applicant. But whereas the inventors, that is the research scholars are given the rights of inventors.
Right.
They are considered as the inventors. Because while the institution is considered as the applicant, why? Because they are giving all the grants and all the facilities,
Right.
and mankind, instrumentation, everything comes from the PI and the institution part. So they are given the rights of being an applicant. So applicant.
Yes, right.
Yeah.
For the research paper is the a particular author, but for the patent, no.
For
The university shall get the applicant
university has
status.
the-
Yes.
Yes. So that is how we balance yes, copyright and
Yeah,
patents.
that is
So see how they are so much connected, copyright and patents. So in my opening line I said yes for the research and scientific
I'm
invention.
very sorry, can I ask you one more question?
Please.
Because it was very nice topic.
Yes, sir.
You presented well. I hope we have time. Sorry, I know you are all hungry. Okay, so you mentioned the copyright. Suppose I have a website. I developed a website for my company or some lab or something. Then do I need to take a copyright or it is
The
already?
thing is that during your employment, like I said, no, your employer shall be the copyright. For the in the course of your employment, whatever I mean the cooperative work, whatever work you are created or made in the course of your employment under the guidance of or under the authority of your employer, the employer shall be the copyright. Even for the website also, it seems like you are made that website under your employers, under your contract of employment only. So the employer shall be the copyright.
Okay, suppose I, the employer, so we have filed copyright for that specific website.
Like the company shall be it. Company will have to be
Suppose,
it. Because the individual, but if you are a freelancer, and you have created your own one, so that for whom like you are creating the particular company, that website, that person shall have the that website owner shall have the control over the website particularly. But you being a developer, you cannot claim direct copyright because you have been paid the fees for creating your website, right? Yeah.
The same thing, like the owner of the website.
There are certain subtleties in all these things actually.
I understand. So the owner of the website. Suppose I
Yes,
the
because you
website.
can see in the website, the copyright posted a particular.
That is what I'm saying. Suppose I launch the website today, and I launch the website today.
You will not be launching because you are just a developer only. You are being paid fees to. Oh, okay. Being an organization or
No, suppose I come like
your
I ask.
own website.
Yeah.
You are the owner of that particular
Right, but
website.
then do I need to take a copyright?
Yes, because because that mark shall be used, and created by someone else. So if the person claims it, so better to take a certificate of registration. And the websites are big things. They are not like simple
Yes,
research
yes,
papers.
that's what I'm
Like you cannot claim copyright for individual papers like that. No, website is a big thing, so you have to claim the copyright. Being an institution.
Thank you. Very informative. Thank you so much.
Thank you so much.
Thank you all. It was an interesting. Now we shall be proceeding towards the lunch break, and after lunch break, we will continue the session. Thank you all.
Hello. Hello, hello. Hello, hello.
Sir, please, ma'am, please. Dr. Pervin Abraham, ma'am, is a patent agent and IPR associate at TPIIT, Sree Chitra Tirunal Institute for Medical Sciences and Technology, Thiruvananthapuram, Kerala. A big round of applause, everyone. Thank you, ma'am. Now we would resume the technical session.
Now, as we proceed towards the fourth technical session of the two-day workshop, let me please take a moment to introduce our next resource person. Professor Dr. Devashish Poddar sir holds an LLM MPhil in law and PhD along with masters in 3 social sciences subjects of political science, literature and education. He has over 80 publications in several flagships journals of national universities. Sir has been awarded the fellowship by the International Labour Organization for his visit to International Training Center in the Italian Republic. Sir held the position of Dean at Xavier Law School in St. Xavier University, Calcutta, since its inception. Sir is currently the Professor of Law in the National Law University of Assam. Today, for this session, Sir shall be speaking on the traditional knowledge of intellectual property. Can you please welcome him with a big round of applause? Sir, over to you.
Good afternoon. Am I audible? Yes, mic is working. So sometimes if something happens, otherwise let me know. So I was just engaging some interaction with some of you who have been from. So why don't you come here? So this is a small gathering, so it will help us to engage, to interact. Please. This is not enforcement, this is advice. We will like. So, let us start this journey that traditional knowledge. Usually in law schools, all of you have law, I guess, no? So, mixed. So, I will not take you to technical legal jargons, etc., because that will create distance. And as a classroom teacher, primarily, this is not, I don't take it as classroom teacher role. That is why I have come down to the level playing field, because some of you are professors, like Professor Rajan, etc. So let us take it as an exchange. This is the 20th anniversary of my journey through traditional knowledge. I started understanding traditional knowledge, and this understanding, this journey is still on. Traditional knowledge I started understanding in National Law School, Bangalore, which is the first and one of the premier institutions. So there my LLM dissertation, master degree dissertation was on traditional knowledge. But within traditional knowledge there are several subsets. I was working on traditional medicinal knowledge. I am not going to share my experience in details, but take it as a starting point that I started with traditional medicinal knowledge. So out of that understanding, at that later point of time, I offered courses on traditional knowledge specific, it is not mainstream IP. To few other departments not belonging to law, few other institutions. So out of that, I'm starting. So since it is primarily half an hour journey, because I wish to keep at least 15 minutes out of my session for Q&A. That is more important, because that will give me opportunity to take something has taken, because that is also very much important from this type of session where cross-disciplinary assembly of audience is there. So first 15-20 minutes I will be speaking on traditional knowledge in itself. Thereafter I will try to, since this is primarily focusing on technology transfer, so I will be focusing on technology transfer, but due to my background in law, I will be focusing, I will be offering my perspective from law background, but I will make sure that it will be intelligible to those without law background. So, as I promised, that first 15-20 minutes it will be traditional knowledge. The jurisprudence. Jurisprudence is a technical term, but I am simplifying. That is the philosophy of law behind traditional knowledge. And second part will be some of you, those who are practicing as patent attorney or some technology background. That may help you better to understand the way we lawyers in law discipline, the way we try to understand technology transfer. Because technology transfer is primarily a scientific process, but legal process is also involved. So how we look at, in case if there is any dispute, how the court will look at technology transfer, that part will be my ending part. So let us start with the genus traditional knowledge. Traditional knowledge, usually we offer in the mainstream IP legal education as a subset, as a module. There are other modules. I am trying to give you the genealogy of IPR. That in IPR, I will not repeat what is there in ChatGPT or Google, that intangible asset, etc. But I will start this after what is traditional knowledge. So that way, before going into that, I will take 3 to 4 minutes to make you understand that how, where is the location of traditional knowledge in the IP family, in the IP as a knowledge group. So here in IP, broadly, we divide this entire discipline in 2 parts. There are other perspectives of dividing, but one of the dividing line is most of the IPs are commercial IPs. I repeat, most of the IPs are commercial IPs, whereas few IPs, relatively fewer IPs are social IPs. Commercial IP domain, that is starting point is patent, because if you take the genesis as the Paris Convention, it is on industrial property, so primarily patent, though there are several others. In fact, the genesis of GI is also in the 1883 convention. But I will not go into that because it will create digression. So 1883 Paris Convention followed by Bern Convention 1886. I am not going to take you to the history of IP, but come quickly to the traditional knowledge. Traditional knowledge belongs to social life. Quite unlike patent, copyright, but copyright has subsets. If you take economic rights, if you take moral rights, so right to recognition is moral right. There is another very interesting question, that whether or how far intellectual property rights are human rights. Very important question. So that also I will touch upon, because that is important to understand and appreciate traditional knowledge. So with these both perspectives I will cover in the first half. But coming back to the point that patent, copyright, trademark, design, semiconductor, integrated circuit, etc., etc. Why etc., etc.? Because there are several other little hazy areas are there, like trade secret, like technical know-how, like confidential information, or like goodwill. So exactly where to put? There are some are sui generis. Also, there are questions whether or how far those are those belong to intellectual property domain, like goodwill. Can we actually locate goodwill in the IP discipline? So, if we take WIPO definition, which is a click array, you will find that WIPO does not recognize goodwill as intellectual property. WIPO has made one liner that goodwill is intangible asset. So goodwill is have you seen any law on goodwill? There is nothing. There is no operation of goodwill. We cannot license goodwill. But goodwill is a very important factor. Those who practice, they are aware is in practice. So goodwill comes into play in terms of transfer of intellectual property. When there will be sale of a property, some industrial establishment, say for example government or Tata, as such goodwill is not quantifiable. But when it comes to handover of this entire establishment, goodwill cannot be shared. Like patent may be given into lease, license, patent can be sold also. But there is no license of goodwill. So that way now where to put goodwill? In one side, WIPO is clear that goodwill is intangible asset. Innuendo lies here that goodwill is not intellectual property, but remember, WIPO is covered in its official website. That is something. Otherwise, WIPO never covers crime. WIPO never covers transfer of property, movable or immovable. But WIPO is actually thinking to make it clear that it is intangible asset. WIPO never said that it is not intellectual property. So it is somewhere, I call it appertinent to intellectual property, which is not within the domain. Many several privileges, bits and pieces, enclaves, the law students, they know that between Bangladesh and India, there are several enclaves. Berubari case, that was Pakistan border. Likewise, this is one among the enclaves in the IP domain, goodwill. So WIPO thought to make it clear that it is intangible asset, but still it is coming to the purview of IP domain because first WIPO thought that it should be made clear. Another, WIPO never said that it is not it is not negation, but it is clearing the location. So that way you will find that primarily whatever I spoke about for last few 1 or 2 minutes, patent, copyright, etc. All these belong to commercial IP. How I am distinguishing commercial to social IP lies here that IP originally from historical background, it is an offshoot of modern individualism also and capitalism also. Because when Renaissance started Western Europe, because Western Europe is the birthplace of IP. Paris, Bern, both France, Switzerland. So how it started? The way it started by Renaissance, Enlightenment. That way you will find that initially IP was not conceptualized. Say for example, when James Watt invented steam engine, it was not patented. Likewise, telegraph was not patented. Spinning mill was not patented. Or shipment, who invented ship?
not patented. Today, the binary discourse, this 0-1, that is patented, the order. But originally it was invented in India, good old days, it was not patented. So until Renaissance started, Enlightenment started. For good life, they started invention. But the character was very different. The character, the intent of this invention was public good. I repeat, intention was this, behind this invention was public good. So how public life, public welfare will be furthered? So for progressive development of the society, before IP, it started. But when capitalism came into existence, so that is the starting point from propertification of ideation. By ideation, I am clubbing ideas and expressions both, because expression is nothing but a reflection of ideation, isn't it? So I am writing something, maybe Tagore wrote Gitanjali. Gitanjali is the expression, but expression of what? Expression of ideation was there. Something ideated that went reflected in the expression. So that way, copyright also is actually protective mechanism for ideation. Coming back to the point very quickly, that when commercial IPs are many, because original idea for propertification of ideation was in commercial level, but social IP also started its journey, slowly yet steadily. As we know that slow yet steady wins, the tortoise. Social IP is reflected in our subject from our, if we put the legal lens. Social IP is reflected in broadly two domains. One is GI, geographical indications. Another is the TK, for which I am here. Now, GI and TK both are people's side. Quite contrary to other commercial interests, commercial rights or commercial interests, which are meant for either individual or group of individuals, or in other words, either for natural persons or for juristic persons. Juristic persons in this subject we call, say for example, some body corporate. It may be a company, it may be corporations, like pharmaceutical corporations. Today, most of the life-saving drugs which are patented, they are patented maybe by Clindia, maybe by Citra. This is academic discourse, that is why I am naming. Idea is not to hurt their interest. So that way you will find that today life-saving drugs, in case if effective medicine for cancer, it takes decades and it takes billions. Now who will spend? The original time is gone and it is gone forever. That somebody is using laboratory, Madame Curie, etc. The individual scientist is engaging research and some ideation patented for protection of commercial rights of the individual, that is gone. Primarily copyrights are there for body corporates, the big commercial houses, because who will spend 20, 30, 40 years, decades, because life will go. Who will spend billions? So that way, now that is why I was trying to connect IP with capitalism. Because what is capital? Karl Marx clarified that capital is the accumulated power of money, the power out of accumulated money. The way we earn our livelihood by monthly salary, that is not capital. But if it is a million times more, which can run a establishment, which can run a factory, then it is capital, which can contribute to the mode of production, which can establish production relations, which can run some establishment. So that is capital. And that capital is with the enterprise. It is no longer with individual. Now earlier it was there. So that way you will find that the original object and purpose to protect individual interests. I promised to you that I will connect it to human rights. Now I am taking that angle. That IPRs are not human rights. Primarily, there are exceptions. And here I will connect you to the social IPs. Social IPs are, broadly, social IPs are human rights. Commercial IPs are not. I promised you that I will establish this within next 5 minutes. Commercial IPs are not human rights because human rights refer to a technical meaning. In law discipline, law is a social science. Human rights refers to a technical meaning. Human rights are, all rights are not human rights. All human rights are rights, but all rights are not human rights. Human rights, to be qualified as human rights, the right must be inalienable from the human being, non-negotiable for human existence, without which meaningful human life will be reduced to a naught, NNUGHT. So if we take this lens, the technical human rights, you will find that IP rights, so far as commercial rights are concerned, those are not human rights. Because 1902, the positive argument was developed. Some legal philosopher, he defined rights as those interests protected by law. Rights are those interests protected by law. So, if you take that traditional argument, in that case it may be human rights, but human rights cannot be used in very loose sense. In that case, human rights discourse will be diluted. But what is human rights? Which are basic, which are inalienable, which are non-negotiable, without which meaningful human existence will come to a naught. So IP rights, commercial IP rights, cannot be called human rights in technical sense of the term, because these are essentially interests, commercial interests, economic interests. So without which the life cannot be reduced to a naught, cannot be meaningless. Say for example, the way right to life is fundamental right or human right. Free speech, liberty, basic health, primary education. These are, that is human rights also divided in two parts. Civil and political rights, like right to life, free speech, liberty. Another part is socio-economic rights, which are the, you can understand from the nomenclature that maybe right to right to primary education, or right to public health. Public health, it is not treatment of very sophisticated treatment, sophisticated surgery. That is not human right. But basic human health, basic primary health care, or primary education, these are human rights. So if we apply this lens, in that case, commercial interests cannot be taken as human rights. These are rights. Say for example, in Constitution, in our legal framework, there are three types of rights. Fundamental rights, these are part 3 of the Constitution. life, Article 14, right to life, liberty. There are constitutional rights. Like earlier, Article 31 was their right to property. Now it is shifted to Article 308. So, fundamental rights, it is shifted to constitutional rights. That is also rights. And right not to be hurt, that is there in criminal law. Right not to be hurt is also there in criminal law. So that way I can go on, but since time is short, I am coming to the point that traditional knowledge, we locate it as a social IP, along with GI. Now, after this, any question? Let us take a break. I will also have some breathing space. Yes. One or two quick questions. Not working? So, if there is no question, in that case, let us continue that traditional knowledge is itself a discipline now. In 2025, the way we covered, there are independent courses on traditional knowledge. The bifurcations are traditional medicinal knowledge, traditional cultural expression, traditional medicinal knowledge from the lens of patent, traditional cultural expression from the lens of copyright. Besides, there are several. That is, traditional knowledge actually reflects upon the indigenous and tribal. I do not use or, I shall use and, because tribal population, indigenous peoples, there are technical difference in tribal studies. So there you will find that the way traditional knowledge is, we see it very diversified. I'm giving you maybe 5, 6, 7, 8 examples. There are maybe traditional architecture. Architecture is a science, established science. Now traditional architecture, traditional medicine, besides there is traditional healing practices. Traditional healing practices are different from medicine. Medicine is a product, goods. But healing practices, these are services. So goods and services, these are actually divided in two, because if you take international trade law regime, in that case you will find that original GATT was for goods, but GATT's general agreement on tariffs in services, that is for services. Now TRIPS speaks about the intellectual property. Yes. Yes. I have 5 to 6 minutes. Let us come. Just 5 to 6 minutes, because I'm getting indication from left side.
Okay.
So we have to, we have the responsibility to close it, because the next speaker also, I should do justice with the next speaker. So, yes, coming back to the point that traditional knowledge, if I take my research area, traditional medicinal knowledge, which is goods. But at later point of time, my professor told you have worked only on one area, but what about services? So traditional healing practices, these are services. Traditional cultural expression is another, traditional architecture, traditional farming, traditional meteorology, weather forecast. Now what is this? Most fundamental answer is that this is science, very important. So without any technology, advanced technology, the way, since time immemorial, science is used and technology was developed without laboratory. So this makes a difference, and that is revolution. So this part I hope I could make it, as I told, the traditional knowledge semester course may be offered, full 6-month course may be offered. That I am trying to make it in 30 minutes. Maybe 1 or 2 minutes extension. So here you parts. Now coming back to the point, traditional, the technology transfer part. I am just floating few very fundamental ideas which will be your takeaway from a law school. Now if we take technology transfer, let us take for the first, let us take the first word, technology. Now, what is this? technology. My single point answer for you to offer from this institution is that technology is itself a product of intellectual property. Technology, from where technologies come? It is intellectual property. Somebody or the other has introduced, invented. Now, when we speak about combining IP and technology transfer, which is a real challenge and a very fascinating, mind-blowing area. So, technology transfer in IPR, here we have to be mindful of synergy of two IP regimes, which is known as IP regime that we have already discussed, but which is not known or which is usually not perceived. It is yet to attract judicial attention so far. So technology is itself a product of intellectual property. When technology transfer question is coming, and most importantly, technology is a property. The way intellectual property is a property which is intangible, which follows an all separate algorithm. Technology is itself intellectual property, and technology transfer means transfer of property. The way transfer of houses, transfer of land property. So IP transfer is governed by very different regime, because we have Transfer of Property Act for immovable property like real estate, like land. We don't follow IP transfer accordingly. It is a different regime. So when it comes to technology transfer, so far as technology transfer is concerned, it is still governed by primarily, by and large, the original Contract Act, which is aged back to 1872. So 150 years are over, now 153. So here there is space for contemplation of the possibility of a dynamic regime, independent regime on technology transfer. Because the way original property transfer, whether it is movable or immovable, that is not governing IP. We have introduced different regimes. So technology transfer deserves independent regime. At present, it is still governed by, primarily governed by some rules or regulatory frameworks may be there, but Contract Act will be used as statute in pari materia. Means in common man's perspective, it is related law. So that way here, it is still a hazy space in the domain of law. So this, let us stop here to do justice with my next colleague. So still 5 to 10 minutes are there. Let us engage Q&A. I hope fundamental points I could clarify what I came for. So over to you.
Thank you, Professor Fadar. It was a very nice, and highly informative session. And my question is that you mentioned about traditional healing practice and medicine, and the healing practice is service, but medicine is a product. So why it is like that? And healing practice is those kind of, like, suppose we are using traditionally some oils or something for the.
No. Yes, please.
That is also a service or a.
No, that is medicine. That's if it is an oil, that is medicine. But in case, say for example, roughly, beyond allopathic medicine, sometimes when allopathic medicine fails, it happened in my case just 1.5 years back. At that point of time, physiotherapy made me before you today. Now, physiotherapy, that massage, some techniques, some exercise with their technical support, that is service. But the moment you are coming to oil, it may be liquid, but it is a product. I hope I could clarify the distinction. Say for example, when we are engaging consultancy services as a lawyer, it is services. When I am writing a book, maybe intellectual property book, I am engaged in an edited volume. So when it will be published, it will be a goods. But what I offer in the classroom, that is services. So that way, when I am now at present I am writing a PhD on GI. So this is services. But PhD thesis is a goods, which is a product. But intellectual property is there behind the product. Intellectual property is there behind the services. But goods and services, we in law subject, we distinguish accordingly. Services is some performance. Say for example, medical consultants. This is services. But a particular medicine, it may be injection, it may be liquid, it may be pill, but it is goods. But services, medical consultancy, surgery, plastic example, these are services. So in this subject we distinguish.
But yeah, that is, I came to that, and you mentioned about surgery, so it is more easier for me, to ask the next question actually. So surgery, the method of surgery.
This is the advantage of classroom teaching.
Yeah. So the method of surgery, whether we can patent it. Because if, for a particular, suppose there is a stomach surgery or kidney surgery, the surgeon can use different methods, like in traditional knowledge of, healing practice also. They use different, whether it can be patented or, copyright or something.
I can understand that.
No, as per the Patent Act.
Method of treatment is cannot be patented in India.
In India.
Yes.
But if it is a separate, like nobody is using,
That's
and
right.
that person is.
That's why it is cannot be patented because it is a monopoly, na? It's a negative right. That person particularly using that method for treatment, and if someone needs that services, we have to call that person only. He will not share that method of his treatment. So that is the method of treatment cannot be patented in India.
No, okay. I mean that person is a method, but if he can patent it, okay, and same method, okay, but only thing he who are following that method, they have to maybe get the permission from the person.
It's entirely his method.
Because medicine also is like that.
So here, sorry for interruption. In good old days, when I was student, we call it SFI. Sorry for interruption. So since Madam helped me, I like to supplement. So far as IP is concerned, it applies to all the commercial IPs. In IP, we try to strike a balance between public good, which I have already talked about, and private gain. So far as this method, even if it is unique method, in India, the IP jurisprudence does not cover for patenting, etc. Rather, we inspire that in that case you can join a medical college as a professor. I have my unique way of teaching public international law. I cannot patent it because essentially the entire regime is meant to strike a balance between public good and private gain. So we are social human beings. Ultimately, what is the purpose of law? Purpose of law, in law, it is read as the purpose of law is progressive development of the society. So we still, I understand and appreciate your point. It is actually intriguing. But so far as the law is concerned, law is a social institution. It is an apparatus. Everywhere there is no answer. But so far as the larger philosophy is concerned, we believe to prioritize public gain over private good. That is why we use compulsory licensing. During COVID, we actually applied compulsory licensing because there is a common law principle. Necessity knows no law. Necessity knows, K-N-O-W-S, no law. So when the disaster period came, that COVID, at that point of time, we have actually applied the compulsory licensing to get the life-saving drugs in public domain. So irrespective of the inventor, we did not hear, no country in the world heard that whether or however the private individual is losing money or financial interest, because private is for public, public is not for private. So that way, in final count, we prioritize public gain over and above private good, private gain. So public good is over and above private gain. This is the way we try to tilt the balance to engage law and order. That is, law is meant to attain order and arrest chaos. So this is the ultimate object. Law is for progressive development of the society. So this is the way, but this is perfectly, that is no intention to eulogize, but this is perfectly a takeaway for me as IP teacher. I will apply my mind. Thank you.
Thank you for that, actually, because I'm very new to this field. That's why I'm asking these questions.
But it actually engaged my imagination, legal imagination.
Okay.
Now I deserve something. The indication. So, if quick question, one or two.
Can I ask you the
Please.
continuation with that?
Please.
I'm really sorry. Please. And so, in that case, robotic surgery, whether it can be that method.
You are applying patent on that robot, means that apparatus or instrument, it can be patented.
Because robot is a goods.
That the method.
Robot is a goods.
But the method that robot is applying there, that can be. That is
That should be there for the public.
The same theory applies. Robots is a goods, but the method is the services. So there, for that services, society offers thank you. The way after 30 years, society, the institution will say thank you and goodbye. So it is not. I cannot make my unique method or methodology behind the method patented, or it is not IP. IPization is not possible here. Whether it is limits of IP law or prudence of IP law, that is an unsettled question.
Madam, you mentioned about that it is not in India, but other countries
Yes, in US I can say.
it is there. That is
Because laws are very different. It's a jurisdiction in nature.
Yeah.
In India, I have certain limitations. In US and in Japan also there is something. So whenever you are applying a patent in different state, different country, so you can change the amend the claims according to the law. If here you are not applying the method of treatment, you can put in the US. Again here you are go to EPO, means European patent law. There is something different.
Because these IP regimes are nation specific, state specific. State as a political institution, not state of Assam or state of Bihar. State as a political institution, it is state specific. There is no international patent that way it is. But these are also there in larger way. But we are, yes, last step.
Okay, sorry to ask again. In that case, suppose in the laboratory we are synthesizing compounds, we are using a method, whether that method also cannot be patented.
Not in India.
If
Not
you
in
are
India.
introducing something to human body,
Yeah.
if you are introducing something to human, just like vaccine and all other things, in the
Or
method
plasma.
of the introducing.
The plasma is patented,
Yeah.
but the method is not.
But the first case you are using it for the treatment of patients. So in that case, for the sake of public interest, it cannot be patented. But the second case is entirely different, the research case. So in your laboratory, if you are finding out a product with a new process, in that case you can patent both process and product.
The production of
But the treatment method, the scenario is entirely different. That should be there for the public. Yeah, that is there.
That is the position of TRIPS, product patent and process
Process
patent.
patent.
Earlier in India, it is process only. It is limited to process only. After that, after 2005 amendment, I think the product patent will be.
Originally, the TRIPS was introduced in 1995 1st January, but we gave effect of this by 2005 amendment.
Yeah, if you find out something very good or some new compound in your lab, we suggest you to go for both. You should take a product and a process. Both are eligible.
Independent claims.
Last, you go to them.
Oh, yeah.
Thank you.
Thank you.
Let's collect feedback also. Feedback on us. So I leave it to DPIIT chairperson.
Thank you very much, Professor Dr. Devashish Poddar sir. We are truly grateful to you for delivering such an enlightening session on traditional knowledge. We sincerely appreciate your time and effort in enlightening us today. Thank you once again for your remarkable contribution. Now, we shall be proceeding towards the last session for day 1 of the workshop on technology transfer and intellectual property law. Let me take a moment to introduce our last speaker and the resource person for today, Dr. Nimisha K. Dr. Nimisha K is a registered Indian patent agent. She holds a PhD in genomic sciences and specializes in molecular biology, genomics and life sciences. Ma'am is an aspiring IP professional transformed from bench research. She works with researchers to promote technology translations. Her expertise extends Sorry for the interruption. Ma'am works with researchers to promote technology translation. Her expertise extends to understanding and applying the Indian Patent Act and regulations. She has attended several national and international IP-related courses, including the STEM courses and licensing and the research and development collaboration essentials and the prestigious Patent X course, jointly organized by WIPO and Harvard Law School, broadening her understanding of international IP framework. Ma'am is currently working as an associate IPR at Regional Tech Transfer Office, 5th Estimate at Sree Chitra Tirunal Institute for Medical Sciences and Technology, Thiruvananthapuram, Kerala, where she collaborates with scientists and researchers, actively engages in discussing and addressing their IP-related queries and requirements. Today, Ma'am shall be speaking on the topic, the role of IP policy in driving innovation and technology commercialization. Let us all welcome her with a round of applause. Ma'am, please. We'll take just 2 minutes. There is some internet issue.
फिर हो जाएगा ये सिस्टम का अपडेट दे दिया तो वो देखते हो जाएगा अपडेट का कोई गारंटी नहीं इसका नहीं नहीं ये हो जाएगा क्योंकि ऑलरेडी डाउनलोड हो जाएगा सर ब्लॉक करके रखना है सारे दिन क्या रहा किसी ने भी मतलब क्लिक कर दिया ये प्रॉब्लम है किसी ने तो क्लिक किया है नहीं तो नहीं आता ऐसा और लोग क्या करते हैं अभी तो उसका नहीं रोक सकते अभी वो नहीं जैसा होता है ये 32 हो रहा है ना सीधा होगा 66 उसके बाद सीधा इसको भी
also explore the intersection of IP with academia and industry. Okay, so let's begin. So, life sciences have, so these are the, let's begin with the innovation areas in life sciences. So what are the innovation areas? So, I think I didn't take a break. So as you know, biotechnology, healthcare sector, and which contains the genetic engineering, immunotechnology, the biochemistry, microbiology, all these areas. And then when coming to biomedical sciences, these are which have this innovations in these areas, mainly the medical devices, biomedical instruments, laboratory instruments, dental implants, of course, and then agri-based, agri-biotechnology, this is the genetic engineering, and crop-based crop protection, genetic, transgenic plants, biopesticides, biofertilizers, and also bioinformatics is another important area where innovations happens. That is gene prediction, finding sequence alignment, protein structure prediction. So all these areas, if innovation happens in these areas, they have a significant impact in the society as well as impact in the economy. So as you know, the technological commercialization process happens through different phases. That is, we have the invention phase. Invention phase is where the research leads to inventions. The research which happens in the academia, it leads to inventions, and then comes the product development. Product development is nothing but turning where ideas are turned into the prototypes, and then which leads to manufacturing. Manufacturing means scaling up of the products developed to the next level, taking it to the next market level. Then comes which is followed by marketing and sales, and which ensures it to the industry production. Industry adoption. So IP policies. So what is the role of IP policy? IP policies and technology transfer plays a very great role in all these areas of technology transfer, commercialization, all these processes. The IP plays a very important role. The need of IP policy is very important and in each and every stage of these process. So they ensure that not only the intellectual property is protected, but also the innovations is commercialized effectively. So these are the institutional mechanisms for science and technology in India. So our government, which is the funding agency, this is the Public Research Funding Agency, which has crucial bodies like DPT, DST, CSIR. All these bodies, what they do? They play a central role in promoting research and development in our country. So these bodies facilitate the transition of innovations from the academic background to the industry. So where the fund is needed. So there are several policy making, policy implementing agencies like DPT and also the ICMR, the CSIR and all. And there are regulatory agencies such as the Review Committee for Genetic Manipulation, Genetic Engineering Approval Committee, and recombinant DNA Advisory Committee and all. All these constitute, they help in taking up the inventions, the research into industries. And then also there are international agencies which engage in the policy making and all such as the World Trade Organization and all. So what we need is a strong IP framework which is very essential to drive this innovation. It incentivizes research. It incentivizes research by ensuring the intellectual property is protected. Okay, and then which also kind of motivates both the researchers and also the industries to collaborate and work together. So, why we need an IP policy? IP policies, it plays a central role in science, technology and innovation policy of a country. So, if technology, an IP policy, if that policy is adopted, it will play a very crucial role in all these areas of technology. And then, if IP policy is used efficiently as a policy tool of innovation, it helps in the transformation of a country in an R&D driven economy. And also where there comes the importance of the national IPR policy. National IPR policy which works as a tool to achieve the goals of a innovation policy of a country and also sustainable development goals of the world. So India, as our in the morning session Professor Ahuja has said, we have a national IPR policy which was formulated in the year 2016. And bringing such a policy document itself gives an important signal that India's intention to develop a strong IPR strategy for the country. So what are the key objectives? He has mentioned, he has given a small hint about the 7 objectives of national IPR policy. So what are those? So in the first and foremost objective of national IPR policy, is the IPR awareness, promotion of IPR awareness and outreach programs. So from the basic level itself, from the school level itself, IPR has to be inculcated in the curriculum. So this is one of the basic objective of national IPR policy. And also celebrating IP creators. People who work, who create IP, they should be given more recognition. And proactive training and education of researchers in public and private research organizations. Okay, they should be properly trained. Training programs should be there about the IPR, like this program, outreach program. So these are very important. And another important objective is a generation of IPR. That is, after creating a baseline survey in different knowledge domains, there should be targeted programs to tap the intellectual property. And there should be royalty share. There should be guidelines for royalty sharing between the institute as well as the creators. So that is one of the objective of national IPR policy. Another is the legal and legislative framework, which includes compiling with the TRIPS, whatever TRIPS agreement has given. So we are signatory to TRIPS. So such things has to be incorporated in our policy, and also we should comply with the national treaty without compromising at India's interest. And also there should be constant review and revising of the existing IP. So these are, and another objective, if I say, is administrative and management. See, if you see now, because of introduction of this, according to national IPR policy, so we have in patent law, there is expedited examination process, expedited grant procedures. So that patents are granted in an expedited way. So, and also there is creating effective mechanisms, and also there is schemes like startup intellectual property protection schemes to help the startups. And commercialization of IP, see, more funding mechanisms have to be channelized. And there is also like tax relaxation. So tax exemption is given to startups for 3 years. And the next important objective is enforcement and adjudication. Enforcement of IP law. That is a dispute settlement and all. And another thing is the capital, human capital development. As you know, there are patent agent and trademark agent exams being conducted. So in order to bring more people, more experts into this field. So all these are the different, different objectives that national IPR policy is given, has given to us. But many of the institutions, many of the people they are not aware of it. They have to take up these policy in mind while creating an institution policy for themselves. So in India, what I want to say is IPR policy is very much integral when it comes to science policies, technology policy and innovation policy as a whole. So what is science policy? Science policy is nothing but it focuses on production of scientific knowledge. So and it is influenced by education policy, budget allocation and other research policy funds. And then the technology policy, what we see, commercialization of technological knowledge. It focuses on commercialization of technological knowledge and it is also influenced by the competition law, trade laws and other policies there. So what IP thinks? IP policy plays a central role in innovation, the technological policy and a science policy. So it is the protection of science and technical knowledge, and which is again influenced by the international IP laws. So on the whole, it will influence the innovation policy of a country, which is very much needed. So as we know that IP policy, so why an innovation policy is needed first of all. So what are the key objectives of an innovation policy in a country? So innovation policy is nothing but the economic growth and as well as the international competitiveness. So fulfillment of these objectives is indirectly related to the knowledge base in the country. And what is the knowledge base? These are nothing but the research institutes and educational institutes in our country. So strengthening an IP system to protect knowledge created and promotion of IP awareness is important aspect of innovation policy of any country. So as I told, the IP policy and higher education institutions are primary building blocks of innovation. So where it aims in promoting generation and commercialization of IP knowledge bases. So let us take up two scenario about, suppose the faculty at a university, he conducts a research, okay, and he develops a very good product, very good innovative product, and what he does is he goes and files an IP. He files IP without the knowledge of an institute, and even though he has used the resources there, he goes and files an IP without informing the institute. What will happen? See, if there was an IP policy with the institute, the faculty might have known that he will be getting all the funds and all the incentives for acquiring an IP, but the ownership will be with the institute. So that things are defined in an IP policy. So every institute must have a very robust IP policy to define all these things, and the faculty and the students, the researchers must have knowledge on that. Okay, so if there was an IP policy in the first scenario, where then the ownership thing will be very clear. So the institute will be the owner, and there will be a win-win situation in both cases, because there will be a hassle-free solution to the researcher or the faculty who is going. And second scenario, it is about the commercialization. If the IP has been commercialized by the institute, and now there is a dispute arises between the royalty sharing of this commercialized product, then what will happen? That if an IP policy is there in place, the revenue sharing norms will be clearly defined on this policy. Then there will be no confusion among the researchers and the inventors how much royalty each one of them must get. So that there won't be any dispute. So that is the need of an IP policy in an institutional level. And also the inventors, they will get recognized. So they won't be they won't have any fear. Okay, my work, my efforts are not being recognized. So they will get the royalty, and that will be a good, win-win situation to both. So why IP policy is important for academia? So what it does, it helps to protect and monetize research innovations through patents and licensing agreements, and it enables academic institutions to collaborate effectively with industry while retaining the core IP ownership, and also facilitates knowledge sharing and technology transfer between academia and industry through strategic partnership, and also it helps in attract investments and funding by demonstrating committed to protecting intellectual assets. So what are the key challenges faced by academic institute or research institution in India? So first and foremost is lack of awareness. Lack of awareness and understanding about the IP policy at the national level and how to bring about in our institutional setup. And there is conflict of interest. And another thing is cultural resistance to change. So researchers and academic people, they are prioritizing publication over patents. See, what happens? It won't help in developing into commercializing their product and driving them into in the economic benefit of the society. So there is a hindrance there. So institutions' problem to design an IP policy. What are the problems where institutions face while designing an IP policy? So universities and academies feel that teaching is a priority, with research and publication being a secondary objective. And sometimes teaching loads is such that there is no time to devote to research and publication. And funding about the research, funding on research is sometimes inadequate. And laboratories and research, sometimes they feel there is an inadequacy in laboratory and research equipments. And also we see the migration, the brain drain, what we see in India. So topmost researchers, they go to some other nations because there is a very good IP framework, protection for their work. Where our protection, IP system is very weak in some institution. So they prefer going out. So there is a problem of brain drain among researchers to other countries. So what an institution faces without an IP policy, what problems may arise? So they will fail in negotiating the research collaboration agreements. See, with the overseas universities. So researchers, they themselves face the responsibility to access, solve this issue. They won't go to a legal expert or commercial advisors. So these are, and also there will be a prolonged agreement finalization, which may frustrate the collaborators also. Okay, and a research organization may take up months to sign a confidentiality agreement for required sponsored research, because there is no policy to guide them how to go about it. And there is lack of promptness in executing straightforward, executing a straightforward confidentiality agreement deter potential overseas collaboration. So, and also then university faculty may not be aware of the approval process, how to participate in commercialization opportunity with the company. So these are some of the problems. And again, practicing of grant of exclusive or non-exclusive right to SMEs without considering the actual status of the possible options. And there is mistaken belief that researchers should not own there is intellectual property. And as I mentioned in my earlier slides about the employer institute, the conflict, who should own the patent or IP, or how the revenue sharing should happen, all this. So all these problems, what it points is that they need an IP policy in order to make things smoother at a university or academic level. So an efficient policy, what it will do? It will facilitate, help in engaging with the industry, help to collaborate with the industry, and also in securing industry funded research, and also help in efficiently handled research agreements, collaboration alliance agreements, license agreements, and other commercialization agreements. And also help in identifying the exact, the protectable, the worth intellectual property that can be taken to the next level, that is to the commercial level. And then facilitating the production and commercialization of IP through startups, help in creating startup, help in licensing the technology. All these aspects will be very clear if you have a very good IP policy at your any institution. So what are the key considerations while designing an IP policy at academic or research institution? First of all, we have to see, first key consideration is ownership of IP. That is, if there is no significant use. So I have listed out certain scenarios. If institutes resources are not being used, how should be the ownership? And if there is a sponsored or collaborative activity, how should be the ownership? And then also there is if significant use of resources from the institute is used, what percentage or how the ownership should go. So all these things has to be considered while drafting an IP policy. And now comes the disclosure policy. How an inventor or a student should disclose his or her invention to the institute. So there will be very, if they have a policy, it will be mentioned how it can be constituted. And about the confidentiality, what will be the institution's role? How people should, if there has to be a disclosure, how that could be disclosed? The measures taken by the creator. And the fourth consideration is making an IP committee. That is an organizational setup inside the institute, so that the patentability, these aspects for obtaining patent as well as for renewal of IP rights, if there is a committee that will help all the researchers and also the academicians how to go about. Okay. And the fifth consideration is filing application with foreign countries. Many of the researchers and faculty, they don't know how they can go about. So if there is an IP committee, they can very well make them understand how they can go, and they can help them in executing those complex forms and all. And about the contracts and agreements, and it should be considered that all the contracts and agreements should be approved by the organization. And then comes the technology transfer part. And if they are commercializing the product or a device developed at their institute, how they can go about commercializing. And if the institute is unable to commercialize, whom they should approach. These things has to be considered. And then revenue sharing, as I have been telling in my previous slides, revenue sharing is a very important aspect. So how the revenue should be shared after the commercialization happens. And then reassignment of IP rights to the creator. And how the co-creator must, about the revenue sharing. Must get how much portion of the revenue that person must get. And then comes the infringement, damage, liability and indemnity insurance. This also has to be included in the IP policy. And then conflict of interest concerning inventorship. The head of the institution and other relevant authority must approve. Approval is needed for their license or agreement. These things has to be included. And again, dispute resolution and that right to regulate policy. So the IPR policy must be reviewed at least by every 3 years. So that it should comply with any the national level, whatever changes coming in the national level, it should be reviewed in the institutional level as well. Okay, so what and also the jurisdiction, it should obey the rules in the local jurisdiction. So if a robust IP policy is there, then an institution, it will be benefited to the institute, the people who are there, and the faculty members as well as the students and researchers, they will be guided. So university, industry, tech commercialization in India. So we know that there are countries like globally, if you see USA, Japan, Israel, all they have very well developed technology transfer offices as well as IP sections. And what they do is they the research which happens, the invention which happens at the university, it is very well commercialized. So India should take up model from those institutions. So this is one of the paper, recent paper in 2020 by Ravi and Janodia, which was published in the Journal of Knowledge Economy, where they proposes a good model where an industry, a university can take up how to go about, so that their inventions can be taken to the next level, to the commercial level. So first of all, if you see, they say that university, the research outcome can be divided into, like, it can be patented, it can be three different levels. So product, tech ready for commercialization, publication and IP. Then there should be assessment at the TRL levels, that is, the technology should be assessed at what level it is existing. So that kind of assessment has to be done from the university, from the very early stage itself. And also what they proposes is that the industry should be have a very good intervention at the initial stage of the project itself, so that the project could be developed in such a way that it can be finally taken into a licensing agreement or a tech transfer. And there should be market analysis, that is market assessment. If the product develops, how it can work in the market. So what is the present market status? All these things has to be considered at the initial stage itself. And also the commercial viability. It has to be checked. How much commercial potential it has got. And if it is readily, it can be commercialized, then it can be taken to other things like for licensing, the exclusive license. You can decide it should be go for exclusive license or non-exclusive license. And also the how much then you can think about the royalty milestones and etc. If it is not commercially viable, then don't take it for patent application. Then just go for publication. So IP management in academia is very important, and technology transfer offices has to have a great role to play. So what are the key requirements? So what IP management, there is a early detection, identification of protection. Which invention at the early stage, it has to be, it can be decided whether it should go for a publication or it should go for a patent. And there should be clear IP policies, and also IP education, of course, IP education and awareness, strategic portfolio management and collaboration management. So just I have listed out the roles of TTO, it is very general. So in protecting IP, so what TTOs do? The Technology Transfer Office, what it does? It manages invention disclosures, help in patent filing and prosecution, and helps in maintaining portfolio management and also record keeping. And the industry point of view, what it will do? It will help in building industry partnership, managing corporate sponsored research, and helps in network development. And the commercialization support, what it will do? It will do the market analysis, market assessment, and also negotiating the licensing agreement. So every academic institution, they must have an in-house technology transfer office also, and it needs technology experts, the technology transfer experts, in order to guide in all these areas. So with that, I would like to conclude my talk. First, so strengthening an India's IP tech transfer system, what we need. It is increased IP awareness across academia, and more active technology transfer officers to manage the IP portfolio, and a stronger industry academy linkage through clear and defined IP policy. Okay, thank you so much for listening. Okay, if any questions, please do free to ask me any doubts. I'm there to answer.
It's a very general question, Dr. Nisha. It is a very good talk and it was very informative. You covered a huge topic in 30 minutes.
Yes, yes.
Okay, so
It's a huge topic.
Okay. So you are talking about IP policies as well as the importance of these universities and institutions to take care of the students and faculties working in those institutions. So I think it is many institutions are already started working on this area and a lot of courses and those things and IPR cell also there. So how much we have achieved so far compared to the global average? What is your
Sir, about big institutes like IITs and IASC, all these have very good, I understand, they have technology transfer office. But in India, when we see globally, they are already there. There are the academic funding research. They all are being funded very well by the industry partnership. All comes at the initial stage itself. But in India, we lack that. I think bigger university. Yes, there is IP and all those things, they are very much knowledgeable, but at the grassroots level, no, the small universities and all, it has to come up. So what I say, it's lacking there at that point.
True. What I have seen, and most of the Indian institutions are, helping to take patent in India, right? So I think only very few are interested or helping their, faculties and students to take, patent abroad.
Yes, yes.
Because I think that is also very important.
Yes, yes. But patenting outside is like more costly process also, and so that's why it's been restricted to India only.
So, but that is also important, I think. Those many countries, those kind of patents also very important. Because it can be, sometimes what happens, whatever we develop, it will be a geographical significance. Even some drugs developed here, they can be used in Japan, but not other parts of the world. Because we are genetically different. So those kind of things, and patent is applicable. If you can take it in Japan, that is better. Yes, right. Yeah, that is.
The problem lies with the funding, especially with the Indian.
Yes, I understand. Even we are also facing a huge issue for funding, even research. See, when I was in US, one small fund is like $1 million, and here that is 10 to 20 lakhs in the rupees. And how we can compete with this?
If you find a good market there, if you feel that there is a very good market for your product, then definitely you should file.
Yes, and I think Indian government also should take some lead on this because if our product or something find technology find good market there, they should help us to take that patent on this.
And nowadays we do have a lot of funding mechanism, especially facilitated through BIRAC and all, and they are taking up such kind of, if your invention is really good, there are a lot of funding systems available to take up such kind of scenarios.
I have a question.
Yes.
Suppose I did my PhD work, okay? And during PhD work, through the experimental, I found some compound, okay? But after that, I did not reported the application of that compound. But after, suppose I joined some other institute, I started working as a assistant person, I started my work there. In other issue means I am started application of that compound. So if suppose I found that is means potential compound, if I want to go to for the patent, so here I have to take the permission from the both the institute or only working institute. You understand my question? Suppose in my PhD thesis I have reported some compound, but in thesis not reported the application of that compound. Okay, now PhD I submitted PhD completed. Okay, now I joined the next institute as a assistant professor. There I started the extension of my work. I started again work, and now in this institute I started application of that product, that compound, and now I want to. I found this compound is means useful to protect the plant against a particular disease. Now I want to patent that compound as further commercialization and all. So here it's required to take the permission from the earlier institute or not required?
First of all, actually you have already disclosed the product in the thesis, right? The compound in the thesis, right?
No, it's not disclosing that way. Suppose I did the means disease plant and resistant plant together, and I do the LCMS, and there I found in the resistant plant some unique compound is produced. Okay, and so I predicted at that time might be this compound involved in the resistant and protecting the plant against the disease. But this much reported in there. Okay, but further application means proof of that compound is actually killing that pathogen or protecting or all this is not reported in that. It's a completely new. Now I started working on that compound and further I did the experiment and found yes, it's killing the pathogen and it's also involved in the efficiently protecting the plant against the disease. Now here I want to go for the patenting of that compound. So here it is required to inform the earlier institute or not.
If there is no contract or anything, you are now not at all bound to that.
Okay, okay.
So there is no requirement.
Okay, thank you so much.
One thing more.
Drug repurposing. So one company can take it, for one disease, but same compound we can also.
But there are so many classes in it. Like, first of all, for taking a patent, you should have some kind of application. So otherwise, if you are not showing that particular application, like if you are showing the compound without any application, that is not patentable.
No, its application is there. It's a protecting.
Application is there, and along with the compound that you have disclosed the application part also.
No, it not disclosed.
You should. Then only it will go.
His question is that he has found a compound in one institution and that he didn't put it in his thesis. But he found that compound and he moved to another institute and then he worked on that and then find out an application of that compound. So when he take the patent, whether he should consult the previous institute as well as no, right?
Right, he can go ahead.
Yeah, okay.
Can also
Thank you so much.
divide it into two parts actually. Like you are taking permission and the patentability. There are two aspects like your question actually. So first of all regarding the application, and the second one is regarding whether to take permission from them or not. As Dr. Divisha said, that you don't have to take permission from them, you can work on it. But the thing is that what I was projecting out is the application, like the application.
Yes, the application is there. We tested it's a application. Yes. So thank you.
One thing, in India, new use of existing things cannot be considered. So things is already available, compound is already exist. You did experiment and find a new application of that compound. So such existing compound for new use cannot be considered for patent in India.
But it can be considered. But there is a clause, sir.
We have
If it can be considered if you can prove the synergistic effect.
Yes.
That compound is not reported against the disease and protection in anywhere in the literature.
Anyway, the compound is not new, and this is a new application of that compound.
Yes, new application.
So we need to improve little bit the value additions or some innovation in that compound in order to get claim.
Okay.
You should show some kind of structural modification at least to get the second.
I will do the composite kind of thing. One compound,
Yes.
another compound, I mix together and then I will.
You should have some value addition.
But I think
But
drug
there
repurposing
also
is
there is
No,
thing
for
that
anything.
you should
It's
prove the
for
synergy.
every-
You can't just mix it.
But
Only
other countries
compound.
drug
I will do the synergy. I am working on that one, the synergistic impact.
Okay.
I am going in that way. So I hope it will work.
Yes,
Okay,
definitely.
thank you so much.
There is no more question.
Thank you so much everyone for the interactive discussion, and thank you so much ma'am. We extend our heartfelt gratitude to Dr. Nimisha K for sharing her knowledge and perspective with us today on the topic, the role of IP policy in driving innovation and technology commercialization. Your thoughtful reflections must have significantly enriched all our participants, and their understanding and also offered valuable insights. Thank you so much ma'am once again. We sincerely appreciate your time and effort for contributing in the day one of the workshop. As we conclude towards the first day of the workshop of IPR and technology transfer, it is my privilege to extend our heartfelt gratitude to everyone who made this first day of the event possible. First and foremost, I wish to express our sincere appreciation to all our distinguished speaker, resource persons whose insightful perspective and expertise have enriched our understanding of technology transfer and IPR. Your valuable contribution have truly made the event impactful. We are deeply grateful to our esteemed chief guest, Professor Dr. V.K. Ahuja sir, guest of honor, Mr. Balram Shankaran sir, respected Vice Chancellor, Professor Dr. K.V.S. Sharma sir from National Law University and Judicial Academy, Assam, and all the esteemed dignitaries for gracing this occasion with their presence. Now, I would like to invite Mr. Ajay Kumar from IIT Guwahati to deliver the vote of thanks. Sir, please, over to you.
So, good evening to all of you. Things evening like almost. So, first of all, I would like to express my sincere gratitude to the organizers for bringing these resource persons to this workshop, and because they are experts in their field and they have shared a lot of knowledge, as well as that leads to a lot of discussions among us, and it was highly informative as well as helpful for us. So first of all, I would like to express my thanks to Professor Pankaj Kumar for his talk on IPR differentiation and patent refiling requirements to grant. It was a highly informative session. It was the first talk, and a lot of information about IPR differentiation and patent refiling he has shared, and it was very, very useful for us. Second, we had Dolly Kumar, a research assistant. She was talking about geographical indication in Northeast India and overview. Since many of us are working on traditional knowledge and traditional plans and those things, her session was highly informative, and she showed about some of the plants, that is like some oranges and ginger and those things that is unique to Northeastern India, and we have filed the GI for that. I'm also working with the Meghalaya government on some of the plants, and the honorary advisor of their farmers commission, and they are also going to file a lot of GI for some of the plants in this region, and her work was very, very informative and useful for us. And then we had talk on copyright in academics by Dr. Sharmishta Barwa, and it was highly, highly informative, and the discussion prolonged almost 20 minutes, and we had to stop because we had to give the time for the next speakers, but it was highly, highly informative, and thank you so much for your, talk. Then we had, after lunch break, so we had a very good lunch. I should appreciate the organizers for that. So, after the lunch, we had a talk on traditional knowledge by Professor Debashish Boda, and he also presented very simply his thoughts as well as rules and regulations, and how you protect the traditional knowledge and those kind of things. And finally, we have talk on the role of IP policy in driving innovation and technology commercialization by Dr. Nimisha K from Tirunal. And she, within 30 minutes, she covered a lot of informations. And these are very, very useful because not only for us, but also universities and other institutions. And she also pointed out the importance of setting up an IPR division and those kind of things in the universities and institutions, and many of these things, even I feel that it is a preliminary stage. And we are not that advanced stage in many institutions, but this is very, very important, and because many of our innovations are not going to the market due to these problems. So it was very wonderful. Okay, thank you. So, and then we have two, very well dynamic, energetic anchors. They also presented very well. I mean, they did their job very well. So I would like to also thank both and both of you. And finally, I would like to thank all the delegates presented in this workshop. So thank you so much.